9:30. The inquiry is resumed. You can all hear me. I know you can hear me. My name is Stephen Normanton. I'm a Chartered Town Planner and Chartered Surveyor who's been appointed by the Secretary of State to hold this inquiry into an appeal made by Cemix UK Operations Limited. The appeal relates to the refusal of planning permission by Hampshire County Council for the proposed extraction of sand and gravel with restoration to grazing land and recreation using imported inert restoration materials. Also includes the erection of associated planted infrastructure and the creation of a new footpath and access onto Hamble Lane. The appeal site is located at the former Hamble Airfield, Hamble Lane, Hamble Roller Ice, Hampshire. Just before we go any further today, can I ask the Council for the usual comments regarding fire evacuation and toilet facilities?
Thank you, sir. Good morning, everybody. So fire evacuation, if you hear a continuous alarm, if you head out the door here, past the restaurant, out the main entrance, and then take a left and follow the road until you see the roundabout, straight over the high street there into Castle Avenue, and the assembly point is outside the Great Hall. Essentially, follow officers and there will be fire assistance to help you on your way if we are in that event. In terms of facilities, again, out the same door, and then just go round to the right, and the toilets are on the left-hand side, just by the Nightingale room.
Thank you. Can I just remind everyone to ensure that mobile phones are turned to silent or off, and email interruptions as well. If we can mute the notification warnings, that would be appreciated. Thank you. Just a couple of things before I go into what's going to happen today. A couple of housekeeping matters. Mr. Strawn around today?
Yes, sir. He's in the other room at the moment, but
he's there.
He has slid in at the back, sir. Yes.
I think you should have received a revised programme following where we were at yesterday.
Did indeed, sir.
Just want to chat about that programme because it's tight. You're either going to have a very long night on Wednesday, or we need to think about a contingency. There is a contingency, and I've mentioned the contingency, I think, at the end of that. I apologise, Mr. Strong, for dragging you up here, but it's probably appropriate. Let me get rid of my opening and I can go to that. As you can see, I think on Tuesday will essentially be all day taken up with highways, and I've pushed the council's planning witness towards the end. That makes Tuesday a late night. But I think if we proceed on the basis that there is some common ground on highway modelling between now and June, that might help us in pulling back some time in the programme. But nonetheless, given our experience of the last couple of days, it's tight. That pushes us on to Wednesday. For the very same reasons, it's tight. And with the best will in the world, if I was stick to the time that I allocated you, and I think we've only met that on one occasion, and I think we only clawed about 5 minutes, you're going to be missing your tea and having your closings in the evening session. I'm fine with that. I'm here anyway. So you can come in. I've had closings at 10 o'clock in the evening. So that's all the story. So I don't mind that, but it's not fair to everyone else. There is a contingency. The contingency is we do the closings on Thursday morning. Now there is a room for that. It's not this room, but it's the overspill room that's been used. If that weren't to be the case, and I have done other inquiries where we've done the closing by Microsoft Teams, but it does require all the facilities to ensure that that is broadcast appropriately. So I'm a little bit in your hands here as to what you, and looking at the advocates, as to what you know better than me in terms of what your timings might be, what you're likely to be asking. I'm quite prepared to be here on the Thursday morning, and we can do the closing then to give us at least a shot at getting these done within reasonable time. I can do it by Teams. I'm not averse to that either. Or we can spend a lot of time on Wednesday night and burn them in now early in terms of that. Is there some noise I keep hearing? All right. So, Mr. Strong, what's your thoughts? And then I'll come round the room.
So I thank you very much for the revised timetable. I agree with you that it looks tight. I'm ever optimistic that we go shorter on our estimates than longer, but that's not necessarily borne out by experience. I appreciate. So in short, if everyone else is available Thursday, I can do on Thursday morning.
Mr. Fulbrook?
He's going to.
Sir, I agree with my friend. I can also just double check that.
I think this is the first inquiry that I've overrun. I've not been cracking the whip. I'm getting too old. Not been hard enough.
We haven't overrun yet.
No, well, no, we haven't. No.
Yes, so I could do the 26th, Thursday 26th. I think it would be sensible to have at least have a contingency available should we need it.
Okay.
We could still aim for the Wednesday and then.
Yep.
Yeah.
Mr. Lewis, how would that affect you?
No, that day was booked out in my diary as a contingency in any event, so that's
Brilliant. All right. In which case, that's helpful. So there's a risk that we'll be sitting on Thursday morning. If we are, it'll be in the ante room where we've been using for the last few days. It's been booked already. The council's anticipated that. So there we go. So thank you for that. I'll leave the. I'll just amend the programme slightly by putting contingency for the Thursday morning so that it's in the programme. And I'll do that. I'm not going to do that today. I'll do that next week. But thank you for that. We sorted on that particular point. Couple of other housekeeping things, some simple things, and just something on the site visit. I have a speaking note from Christine Walton, who spoke on Tuesday. I've recorded that as ID 12, and I think a copy should be sent to Amy to put on the website from John. In terms of speakers at 12 o'clock, the community's helpfully provided me with a reduced list of speakers. So we will be having 7 speakers now at 12 o'clock. We've got 12 well 1, and we can't go past 1, otherwise the site visit goes into the evening too. So at 12 o'clock, we'll start with Councillor Keith House. I have Sarah Sutcliffe, who's a Police Crime Commissioner, Brian Trindrell, Timothy, and forgive me if I pronounce this wrong, Thubron, Andy Daniels, Bill Blaine, and Phil Riley. But Phil Riley, I think his comments will be read out by Jenny Austin. So that's 7 speakers. I understand that they've tried to reduce the speaking time as well to be more focused, so hopefully we'll get through all of those before we depart for the site visit. Just on the site visit, I'll come round in a second on housekeeping matters. Another officer from the council will be joining us, just to even numbers up a little bit during the course of the site visit and ensure that we will get disjointed a bit, but there's enough people around there. So there'll be 3 officers from the council attending today. I've also had a request which should have been sent to you from the school to visit the school. Bear me a second, that should have been sent to you this morning. Hamble School. I've had a request from the Deputy Head, Mrs. Vallely, whether or not we can visit the school today. I'm going to leave that in your hands in terms of organising the site visit. I'm not adverse to visiting the school, obviously not. It will affect programme, but how far we go and how long is another matter we might need to think about. So I'm going to leave it in your hands by me saying I'm prepared to go. If we do need to go, just have a think how we do it. And I'm not going to say anything more than that. You know the programme. There's also a number of matters in that email regarding planning conditions, some of which cannot be possibly taken into account as planning conditions. They're beyond the powers that we have. but it's something that I'll probably have to touch upon that email as we go through the conditions. You look perplexed then.
No, so I'm not perplexed. Just two things, if I could just raise about the email. The first is the school suggests that they try to contact us over the last 18 months. That's something that's been said to us last time. We don't have any record of that, and we have asked the school to tell us where they sought to make contact, because certainly the practice of the appellants has been to, if people would like to speak, to talk to them and engage with them. The only contact we had was just shortly before the inquiry began, with a suggested time, one suggested time where everyone was not available because of preparation for the inquiry. But I just want to make clear, so far as we're aware, there's been no request to speak to us before, but we're very happy to speak, subject to availability, of course, with the school to talk through any of their concerns. So that's the first point. The second point is that, as you indicated, there are requests for a number of conditions, and of course those requests relate to assumptions about impacts from the operations, which, for the reasons will be apparent, don't arise. So, for example, concerns about dust, concerns about noise, and as I indicated, that's already covered in the evidence, albeit not orally this week, but there is a wealth of material dealing with the noise assessments and dust. There are some monitoring provisions that we did talk about earlier in the week, which I think will be built into the conditions, but the further conditions being requested, just to be clear, because we won't necessarily discuss them, we are satisfied wouldn't be necessary, wouldn't meet the relevant tests because of the evidence that we put forward about the impacts of the development. And I remain concerned that some of these requests don't reflect an understanding of the effects of the operation. I know that's maybe a feature, an understandable feature of many residents' concerns, but I would urge those who are still under the impression that there is going to be dust everywhere from what is actually a sand and gravel operation, or noise beyond the boundary with the bunds. I would urge them either to look at the documents or come and talk to us, where we can show them the documents which indicate empirically the effect of the operation. So I just wanted to make that clear, because that's the first time I've seen that request.
Well, it only came in last night.
Well, exactly. But
well, this morning.
Trying to be helpful to
Yep.
the school and anyone else who has those concerns.
Okay, I'll respond in two things. And the first matter you raise is not a matter for me.
No,
It's not a matter I take into account in planning terms whatsoever. The second point, I accept that there is mitigation within the conditions and there is mitigation within the scheme. Quite a lot of these I cannot entertain as planning conditions anyway. They don't meet the relevant tests. Some of the matters they relate to are matters that are relevant to the conditions that will be discussed today. So in that sense, the concerns will be picked up as part of that discussion. So what I'm really saying is, I'm not saying yes and agree with them, but what I'm saying is, where are the relevant conditions that are aligned to those concerns?
understood. Yes.
So, and we'll touch upon, because there are conditions that are aligned to those concerns.
Yes.
I'll touch upon
That's
those.
entirely fair, sir. So monitoring of air quality, for example, is something which is covered in one of the plans. But yeah, you're absolutely right, sir. Yeah.
Okay. You've thrown me off track now.
Sorry, I'm so sorry. That was. There's a danger of calling me back into. I was sitting in the background.
I only wanted you for one thing. I'm okay. All right. I think that's all the housekeeping that I had. I know there's a few things still hanging. Is there anything that you want to tell me, Mr. Strawn, from hanging in terms of housekeeping matters from yesterday?
So just. Oh. Okay. So yes. So three things, if I may. First of all, there is a position statement that has been sent, I think, to the Inspectorate on behalf of Ideal Homes Southern Limited.
Yep.
I've got a hard copy here. It's very short, but just as indicated, they're not present today. But if I can have, well, I've got. Well, let me just explain what I'm handing up now.
Thank you. Thanks so much.
We'll hand them over. The others, please go around. And so that's the first. There is also, as you requested, a note regarding the permissive path and landscaped area to confirm our position, which I'll hand up to you as well.
Thank you.
Sorry, it's kind of...
That's helpful because that might need a chat about in some of the aspects of the section 106. So this is the...
And you're going to come back to that in the 106 session as to how to reflect that. But we're perfectly happy to commit to it, notwithstanding what I said about it being the difference of view about whether it's apparent anyway, but we're keen to put that matter beyond doubt. Sorry, I thought you might be. Sorry, I'll pause.
No, I thought you said there were three.
Yeah, there is a third, and the third thing is just in anticipation of the resumption. There are a number of, I think, documents that were indicated, which we will produce and Staines Common Ground. We will try, if we reach agreement on them, we'll circulate them to you and parties as soon as we can. But that will be before the resumption of the.
I'm not going to set some hard and fast dates on those, I think, because particularly the highways one, that does require us reducing the issues down as much as we possibly can. So therefore, the length of time needs to be as long as it takes, as long as it's done. To be fair, probably a week before the inquiry reopens again. You okay with that, Ms. Fulbrook? No, the 106 will get up. We haven't dealt with that yet, so we're working on the basis it doesn't need updating yet. But I'm talking about the extent of common ground on the highways modelling. What I'm really saying is I'll give you as long a time as we can, as possible, up to the week before we resume, so you've got time to get those issues narrowed down to hopefully reduce inquiry time. Yep, I'm not suggesting it compromise anybody's position. It just puts us on an even footing as to what's the baseline that we're all working from. And
the final matter, because I've just been reminded, is we have printed out copies of the site itinerary route and the locations that will be visited as hard copies, so that anyone on the bus can have them. I don't know if
I will have it because I have an A4 version, so an A3 version is particularly beneficial.
So we can hand those out perhaps later when you're heading out, but there's one available.
I won't record that as an inquiry document because it's already in the inquiry document.
Absolutely.
But thank you.
And anyone else on the bus who's going, we'll give them, make available a copy.
20 years ago, I'd done with A4. A3 now.
A3 now. It's my eyesight.
Another 10 years, I think we'll be like that.
So I think that's all from me. Anyway.
All right, thank you. Mr. Fulbrook, is anything in matters of housekeeping that I need to be aware of?
The only thing I've just been told apparently that some at the back are struggling to hear, and I don't know whether it's possible to turn the
Is it me? Is it the inspector? Thank you.
There we go. Okay, thanks. Otherwise, nothing. Thank you.
Mr. Lewis.
Nothing from us, sir. Thank you.
All right. We'll move on to a discussion now about Section 106 and about planning conditions. A couple of caveats before we start that discussion. First of all, just a reminder that this is a discussion about those documents and nothing else. So when we talk about things today, it's not about restating cases, it's not making statements, it's not raising matters that's already been raised, it's purely focused on those documents. So if we stray beyond that, I will curtail discussions because we need to focus on those documents. The other caveat is that, as I said on Tuesday, that just because we're doing this doesn't mean to say that I've made my mind up. It's something we have to do, and it happens in every inquiry, in every appeal to some extent, that we go through the conditions just to see if there's anything that we need to think about in terms of their drafting that is either erroneous, not right, or doesn't quite sit with what we've heard. When we go through that, there are some rules about planning conditions that's in the National Planning Policy Framework. It's paragraph 57 now or something, I think, I don't know. And the PPG. And there's 5 tests, and I'm going to get them wrong, but they need to be precise, enforceable, reasonable, relevant to planning, relevant to development proposed. So when we go through the conditions, those are the 5 tests that each condition has to satisfy. What I'm going to do this morning, I'm going to start with the section 106 and we'll go through this effectively page by page. I've got some comments on some of the section 106, but we'll see where we are in alignment of those. So I'll lead that discussion and then I'll invite people to participate in those discussions if they so wish. If anybody has spoken on or is speaking today, they're quite invited to sit around the table. It's not the format we would normally have. We'd normally be much closer and I'd normally kick a lot of these people out, but because of the way the technology works in this room, the microphones are linked to the seating positions of certain individuals, so it's not helpful to that. But if anybody's who's spoken or is going to speak, therefore is a participant in the inquiry, who wants to say something about those conditions or the section 106, then please stick your hand up and I'll try and bring you into the conversation. Is everybody clear about that? All right, let's pick up the section. Oh, before I do that, Amy, sorry, I do apologise. Amy, the position statement from Ideal Homes, that'll be ID 13. And the note from CEMEX regarding the permissive path, that'll be ID 14. Thank you. Right, let's have a look at the section 106. This is available online, isn't it, the latest version? I know it is, I've seen it. All right, so I'm going to go through this page by page and just see if there's any issues. That's the only way I think we can do it. There's nothing that I can see as an issue on page 1. There shouldn't be. Which is just the parties and an introduction to the section 106. We then deal with some definitions in the operative part 1, definitions, and that effectively goes through words that are used in the section 106. The definition defines those words. So aftercare period means, the Act means, a Town and Country Plan Act 1990, annual report means, annual review meeting means, so on and so forth. And that goes through right through the words that are covered in the covenant. So where there's a reference, for example, what does the development mean? It's defined. What does council monitoring fees mean? It's defined. So those definitions should be pretty straightforward. There shouldn't be a real issue on that, with one exception from me. Permissive footpath. We've got a conflict between what I've just been given, the plans, and what's in the section 106 in terms of its definition. So that's going to require a rethink. Do you want to say something? Then I'll bring. You need to introduce yourself. Well, not now, but.
So yes, maybe I should introduce who we're doing most of the work on our side. My name's Brian Greenwood. I'm a partner at Clyde & Co, instructed by CEMEX. Next door to me is my colleague Carolyn Morgan-Welker, who has been working with Mr. Hammond, who will introduce himself shortly, on the Section 106 agreement, and with Ms. Kirby-Hawkes. And Ms. Berman from CEMEX has been, again, working with Ms. Kirby-Hawkes on the conditions, and they've had a number of meetings. So I'm anticipating that rather than me doing much speaking, my two colleagues will be taking the brunt of the work.
Okay. So I think there's probably then an acceptance that, in the light of what you gave me this morning, that definition needs just a little bit of rework.
So if it is of assistance, we reflected on how to deal with some of the issues that were raised yesterday, and I did approach the County Council this morning, who had also been reflecting on precisely the same issues, and what we are proposing is that we will either produce a clause, which I had hoped the county would draft, but in fact apparently we're drafting, which will clarify the position, and it would either be a standalone clause in the Section 106 agreement, or we could annotate the plans to cover the point. I believe, no doubt Mr. Hammond will say something on that point. The county are leaning towards a clause. We obviously have no concern either way, but that will be sent to you in due course, but it won't be difficult, and it's just a way of clarifying the position for the local community.
Mr. Hammond, is that the position you think, Billy?
Yes, thank you, sir. Just by way of introduction, my name is James Hammond, and I'm a solicitor for the County Council. That's correct. Yes, we had a brief discussion about that proposal this morning, and it's accepted by the County Council that an updated clause would be sufficient to deal with this.
Okay, I'll come on at the end to where we go from here. I don't have a problem with anything else in those definitions, and I'll just check that if anybody else does, except, and it's not a problem with the definition, it's the Hampshire Countryside Service Path Surfacing, which is Annex 5. And I think that's in the definition somewhere. It is, the design standard. I don't have a problem with that document. What I'm struggling to see is where it's tied in to the covenants. Because it seems to me that that's the document that's defining how the footpath should be surfaced. But when I get to the footpath provision, I can't see how it links. But we'll come on to that. It's defined in there. I ain't got a problem with the definition. I've got the document. But I'm struggling how it applies. But you'll probably tell me when we get to that point, Mr. Hammond.
If you like, sir, it's tied into the definitions of permissive footpath A to E and permissive footpath A, I, and G to H. So there's a reference inside the definitions of each that states that the footpath should be constructed to that standard.
Okay.
But we can certainly include something more direct in the clause.
Show me that. Then when we get to that, pick that point up, because I looked and I couldn't. It wasn't registering with me. So I'm grateful that you've sorted it. But let's come to that point and then just see then how does that tie in to anything that we just heard about the revised one, because it might change the content of that document.
Yes.
All right, those are all the definitions within the Section 106. Does anybody have any concern about, I've raised a couple of ones, but any other concerns about the definitions contained within the Section 106? All right, constructing the deed. I've got nothing to say on that really, that's legal content. Seems to me that's pretty straightforward standard stuff. Legal basis is something that's always in there and I don't have a problem with that. Conditionality, of course it only kicks in if the plan permission is granted, and some aspects of the development commences. I don't have a problem with that. That seems to tie into commencement matters. Ownership matters are referred to in there. That's matter of fact rather than matter of anything that's opinion or debate, I think. And then we get into the developer and owner's covenants. So I'm now looking at section 6. Section 6 doesn't cause me any concerns. The developer and the owner for itself and the successors entitled covenant with the County Council, set out in Schedules 1 to 9. to pay the County Council the development control fee and the County Council monitoring fee on completion of this deed, and to pay the County Council their reasonable legal fees on completion of this deed. That's pretty straightforward. I don't see anything that's contentious in that, unless anybody raised anything. So looking at the council's covenants, the County Council covenants with the owner and developer to only use the transport contribution received pursuant to this deed for the purpose specified in the deed. And in the event that the transport contribution has not been spent or committed for expenditure by the County Council within 10 years following the date of receipt of the relevant payment, to refund the payee any part of the relevant payment which has not been spent or committed for expenditure, together with any accrued interest. That's pretty straightforward too. I wouldn't expect anything other than to see that. If you don't spend it, then you've got some issues. That's your problem. Yep, okay.
Sir, Catherine Else, Claremont Planning, on behalf of the Royal Six Party. It's just one thing that we were probably wanting to introduce here regarding the highways contribution in particular, is that it's the assurance that it will be spent, that those works will be timetabled and that the mitigation will come along. This is the first instance in the Section 106 where our concerns are raised, where the only matter that is covenanted to the county is that it's refunded after 10 years, whereas actually we want an assured timetable that the mitigation is dealt with.
Okay, we'll pick that point up when we get to the schedule, because the schedule should cover your concerns. If it doesn't, then we've got a problem. But I think the schedule will cover those concerns. This is just saying the money's got to be spent. If you don't spend it, they get it back. That's fair. But you need the reassurance that it will be spent, and it's the schedules, I think, that should give you that reassurance, because that then triggers whether or not the development to some extent proceeds. So we'll come back to that point when we get to those schedules. Notices. Don't think there's anything that's particularly contentious in the wording of notices in there. Waiver. No waiver, whether express or implied by the County Council, or of any breach or default by the owner or developers in performing or observing any of the covenants, terms or conditions of this deed shall constitute a continuing waiver, and such no waiver shall prevent the County Council from enforcing any relevant terms of the conditions, or for acting upon any subsequent breach or default. That's kind of a prelim, I think, into the council's powers to do something in the event of default. Pretty standard legal wording, but I think that's the first part of that kind of ratchet of enforcement. Interest, yeah, if you don't spend it, you need to spend it, you will spend it, because you're bound by the terms later on, but that interest relates back to what happens if the county council doesn't spend the money within 10 years. VAT, I'm not going to go through VAT. Spend in advance, that's if the council are required to spend something that is pursuant to some of the provisions of this agreement before the payment's been made. That to some extent is a recovery mechanism for that payment. That seems to me to be reasonable, unless anybody says it's not. Dispute provisions, that's pretty standard in Section 106 agreement. If you can't agree something that's contained within this agreement in terms of its schedules, that's effectively the dispute procedures. You don't see an issue with that. Unless anybody raises anything, it's pretty straightforward. Registered as a local land charge, yes it will be, it has to be. That's a matter of fact. Miscellaneous. Don't think there's anything in there that causes me a concern in terms of its content. Discharge of fulfilment of the obligations when it's been discharged. That seems to me pretty straightforward legal content, unless anybody says anything different. Section 73 permissions, that means if an application is made to change any of the conditions, I think it's that what it means, on the plan application subsequent to any decision being made. That's how this section binds those amendments into this agreement. I think that seems to be pretty straightforward to me. Still regulation compliance to some extent. I've already got the still compliance statement from the county council. That effectively is binding that still compliance statement and the still regulations into the section 106. This might sound very simplistic to you, so I'm not a legal brain, but I've dealt with them before, but that's as far as I can go.
So apologies, thank you. Yes, indeed, it's to ensure that it's compliant with the SIL regulations, that everything within here in the section 106 is compliant.
Third party rights, no provisions of the deed shall be enforceable under contract. Rights of third parties, 1999. I'm not so sure what that means. Perhaps you can tell me what it means. I'm looking at 18.1.
So this is the usual clause that's in here that ensures that there are no other parties who will then claim rights in relation to the 106 agreement other than those parties who are bound by the agreement.
I've never asked that question before, but thank you for the explanation. No fetter or discretion.
I was just going to say, if it's this, that is a very standard provision.
Yep, it is. I know it is. That's what I said. I've never asked it before. I've just flipped through it because we need to just go through these on this particular one. No fetter or discretion. That sounds an incredible phrase. Tell us what no fetter or discretion means.
So this is, sorry to anything Mr. Hammond has to say, the county council, as the county authority, is just, we are accept, it has other powers which cannot be, should not be vetted by anything.
Yep, got it. Jurisdiction, the law of England. Me or?
Sir, can I just interrupt? Sorry. So I think there's a bit of an issue with the mics on that side. Can you just make sure you've got your name on the mic that's in front of you? Because I think, Brian, you're coming up as James at the moment. So we just need to make sure that the mics have your name at the top. So, Carolyn, if you can just check. I think you've got them back to front. So I think that might be Brian's and that might be Carolyn's. Sorry. Otherwise,
that's the reason why, isn't it? Because when they're pressing the button, it's not coming on because they're not the right people. And that's why we can't change seats.
So just to check, am I now live and good? My apologies for not spotting that myself.
All right, delivery is pretty obvious. That's the deed doesn't kick into effect until it's been signed, dated, and executed in that sense. Schedules and annexes, we're going to come on to those. Indemnity, that's a pretty straightforward legal content as well. The developer agrees to indemnify the owner against and pay to the owner all cost claims, losses, damages are directly and indirectly a result of entry into the deed or any breach in terms of the deed. There's nothing in there that frightens me in terms of the content of the development, relevance of the development. That's pretty straightforward standard stuff. Then we have the signature page, which obviously is not signed. And now we're coming to the kind of nitty gritty of it, which are the relevant schedules. Just for my benefit, the environmental management plan just explained to me why this needs to be a provision of the section 106 and can't be dealt with by a planning condition.
Thank you, sir. It's County Council's view that it's a plan that involves quite a high degree of complexity in terms of approving the plan, implementing it, revising it if necessary, and then policing it, that it's beyond really what's possible inside the scope of a condition, and therefore needs to be enforced and secured by way of a planning obligation.
Okay, I'm content with it, but I just wanted, but equally some aspects could be a planning condition, but I understand the planning condition is going to be about 6 pages long. And it's probably a little bit more cleaner to deal with it through this mechanism, I think. All right, so Schedule 1 is dealing with an environmental management plan effectively, prepared by an ecologist. And the schedule provides it not to commence or permit commencement development until that plan has been submitted to and approved by the County Council. I don't have a problem with Schedule 1. I've just put a note at the side of something that I can't remember now why I put that note. I know what it was. 4 of that schedule refers to, it says not to commence any extraction unless all pre-extraction requirements have been implemented and the pre-extraction certificate has been issued to the County Council. Such certificate shall not be unreasonably withheld or delayed. And what was going through my mind is, how does that relate to the pre-commencement conditions that require to be discharged pursuant to the conditions? And how does this interlink with those? Because this seems to me that there's a separate permitting regime here. Permitting, not a permit, but the council's requesting are going to issue a pre-extraction certificate. My concern is, does that infer that the conditions that are pre-commencement conditions have all been discharged by that time? And I'm not so sure if that seems to be blurred.
Thank you, sir. We can look to clarify that perhaps inside the document. For my part, the pre-extraction requirements are requirements that sit within the ecological management plan alone, and therefore are separate and sit aside from any pre-commencement conditions. And therefore, I don't believe there would be a conflict in that regard.
I think it just needs clarifying, because somebody could come along and say, I've got my pre-commencement certificate, even though the conditions might not be discharged. I know that's unlikely to happen, but I think that there is a blur in there between pre-commencement planning conditions, commencement, EMP, and I think it might be something in the definitions that you just clarify as to how this document deals with that blurring.
So that was our concern as well, and also that all of the pre-commencement requirements that are in the section 106 aren't solely within the EMP. So which pre-commencement requirements does it refer to?
Yep, that's the point I think I was making.
Yep.
It's also that we need that clarification. We need to understand how that interrelates, so that it doesn't fetter any consideration of the planning conditions as well. It's reinforcing the definitions and just having to think about that. It's not hard. Anything about Schedule 1 before we go into Schedule 2? Schedule 2 is a submission and approval of the EMP. That's just effectively the council's approval mechanism and timescales. I always struggle with terms like reasonable endeavours, but I'll let you go. I'm not going to criticise legal profession on that one. I'll do it on planning conditions, but yeah, all right. I often wonder how do you define whether it's been an unreasonable endeavour or a reasonable endeavour? Anyway.
Just one matter that we just wanted to raise is, obviously the submission and approval of the EMP sets out various discussions that will be had with county council officers, and the process of it being reviewed, resubmitted and such. It was just whether there was going to be any perceived engagement with the parish council as part of agreeing the EMP, and whether there should be reference to that in that process.
I can't answer that one. I don't know to the extent to which the parish council has been in discussions with regard to the drafting of this, or is expected to be involved in any approval of this.
I don't currently have instructions on that, of course, but from our point of view, this is an ecological document and it's sort of a technical document. And so from that point of view, it will be, we normally anticipate a conversation between our own ecologists and the ecologist appointed by the appellant.
I don't think I can give you an answer to that. It clearly is a matter for its approval, the council's approval process, to the extent to which it involves the parish council. I can't direct the parish council to be involved. It's beyond my power to do that.
So my name is Steve Tilbury. I'm planning consultant instructed by the parish council through the submission of the application and to the appeal. I think the parish council would accept that it doesn't have ecological expertise to contribute to a detailed discussion on the approval or non-approval of such a document, but it would like to be kept informed of the process. And I think that's something that we would take up through other channels with the county council. Thank you for that. I think you probably need to do, because it's beyond my powers to direct something in there to the parish council that's not a decision made. It's not part of the agreement. So I think there's a concern raised. It's a concern that I need to park with you. The extent you resolve that concern is a matter for yourselves. It doesn't affect my consideration of the agreement. It's a matter of the council's relationships with its community. So what you do with that, I think, is a matter for the county council, but it's not something that affects the drafting of the agreement as far as I can see. But point taken, they're going to consider it.
Sir, if I may, just in case it helps sort of clarify things, just understanding, it of course the EMEP relates back to the landscape and ecological requirements, and in the definitions that then lists the documents, at the application documents upon which the EMEP will be based. So the drafting of it will reflect the application. If that assists the parish council in terms of the scope of what's involved, it will be based upon that.
All right. All right, you need to just have a think about that one, but it's not a matter for myself. So that dealt with approvals of the EMP. Schedule 3 is the site meetings annual review of the EMP. I don't have a problem with that. The only, I don't have a problem with it, but it seems to me to be kind of, for a simple brain, fairly lengthy. And I just wonder if there's some aspects of this that could be more simpler to give more clarity and more enforcement. And it seems to me that there's kind of an annual review. So there's a plan, a review of that plan, how are we doing? And then we move on to year 2, review, another plan, how are we doing? And I started to struggle then with this reasonable issue as to where do we get to in that process. If in the reasonable opinion, I'm not so sure if an opinion is unreasonable if it comes from the council, the annual report contains omissions or errors or lacks sufficient detail required for assessment of the EMP, then you're going to give written notice. And I suppose what we're going through in my mind is that it seems to me it's more like the anatomy of a planning condition, that every year you have a plan that sets out what you're going to do, when you're going to do it, and at the end of the year you can quickly review, have they done it, haven't they done it. So that's a deficiency list. So rather than this reasonable opinion, the reasonable opinion can be made quite precise, because if you've agreed a plan that says exactly what you're going to be doing for the next forthcoming year, and you've not stuck to that plan, then the deficiencies are the bits of that plan you've not dealt with. And they then, therefore, should be the matters in which you'll be taking action. So I just kind of got stuck in my mind as to, it starts to get blurred when you start to look at reasonable opinion, and then we have lots of chats about what that means. But it's pretty straightforward in my mind. If you've not dealt with what's in the agreed plan that year, then those are your enforcement matters through the agreement. Then you move on to next year. This is your plan. There's approval mechanism that we've just gone through. You get to the next year, you've not dealt with it. These are enforcement matters. So it just seems to me just to have a little think about, there's a simple process here that seems to be, and I know I'm not a legal brain, so forgive me. But it just seems to me that when I see words like reasonable, I start to get a bit twitchy. Because then we can have a debate for 3 weeks as to what does reasonableness mean. But it just seems to me there's a clear process here that you're trying to aspire to, and I think that just needs articulating to give that clarity. I'll let you think about it. You don't have to give me an answer now, Mr. Hammond. You can do, but if your thoughts. But it's just you. I think you need to have a think about it.
Thank you. Yeah, I'm happy to take that away then. Thanks.
If you think I'm wrong, tell me I'm wrong. I'm big enough and old enough to do that, so don't be frightened of that. But it's just when I looked through it, I just thought, oh, there's a little bit of ifs and buts and oh, shall we, shan't we? Let's have a chat. Are we reasonable? Are we not reasonable? Oh, is it? And I thought, hang on a minute, it's simple, this. Yes. No, it didn't say that.
He said that I think he did. The parish council, the county council.
The county council has.
And I don't think any parish council, the parish council or the parish councillors would take any issue with the fact that they don't have their own ecological expertise of the nature that would be required for a contribution to this discussion.
You okay? You okay with that? All right, yeah. So just have a think about that, whether or not we can kind of make that a little bit more punchier, so we know what the deficiencies are, and then we know what the mechanism for dealing with those deficiencies, rather than leaving that kind of an element of doubt to reasonable discussion.
Sir, just one concern that we had was in respect of the time period to allow a site visit, which is identified as 3 months.
Just direct me to the right paragraph. Is this paragraph 1.2?
1.4? And then it goes to 2 for some reason, so...
Where the County Council requires annual review of site meeting to take place on an alternative review date, the County Council shall provide the developer and the owner with at least 3 months' notice of the annual review date. That does seem lengthy.
It does to me, especially as you've quite ably identified that everything should be there to be inspected. If it's 2 days later, why do we have to give 3 months' notice or something like that? It seems to be overly cautious, as you identified.
Yeah, and I think I take your point, because if you lump that up with 1.2, where they've got 3 months, so it finished on 31st December, you don't have to have the meeting till March, and then, hang on a minute, well, alternative review date might be end of June, by the time you've lost a whole planting season, and some expensive seeding as well. So I think you're probably right, it might be over generous in terms of you've lost a whole year's worth of management. If you're looking at a 6 month potential, there's built-in here provision for a 6 month delay, which seems to be too long. And by that time, the rectification that you've identified from the year before, you can't rectify it until next year because of seasonality. So just have a think about whether that needs to be tighter. It seems to me that it should be tighter. Otherwise, for those very reasons, you lose that opportunity. All right. Anything else before we go on to Schedule 4? Right, let's go on to Schedule 4. This is any revisions to the EMP. And this is... the word reasonable is embedded throughout this, and I kind of get back to that same thing in my mind that could we be more punchy and direct? At the annual review site meeting, or within 1 month of the annual review site meeting, where the County Council reasonably concludes, I don't know what basis you're going to define reasonably conclude, as opposed to just conclude, that the MP is failing to make reasonable progress. Well, if you should be making that progress, if you're tight on that first schedule, to achieve the objective stated in the County Council may inform the developer owner by written notice of any reasonable amendments they require. So you've got to reasonably conclude, you've got to show that reasonable progress is not being made, and then you've got to require reasonable amendments. And I'm using that as an example just to say that there's a lot of latitude in there for discussion and delay, but I think it could quite easily be resolved by tying it back in to deficiencies that can be identified at the annual review meeting on the progress with the plan.
So, if I could, in defence of the County Council, I suspect some of the reasonableness were inserted by ourselves. We will discuss with Mr. Hammond how we can tighten it up as you've asked.
I think it's really for me, and I'm using a planning condition head, not a legal head, so I apologise, Mr. Hammond, and I'm not being critical. I'm using examples just to say, well, this is why I get this kind of fuzz in my mind, that things should be kind of A, B, C, D, E, and I'm going A, F, back to B, over to C. But I think by thinking a little bit more clear about the previous schedule, one before that actually, then it gives you the kind of process to be more tight about this schedule, because those deficiencies should be clearly identified in that review meeting, and therefore the plan that's coming up next.
Yes, thank you, sir. Certainly the County Council wouldn't object to the removal of any reference to reasonable in terms of the exercise of its decision-making power. I think that earlier schedule, which we touched on, there is intended to be some latitude in the site review meetings because the obligation is, of course, to deliver the ecological management plan, but perhaps it's a slightly less definite obligation, perhaps, than say highways obligation. So there might be in any given year an alternative or preferred way or outcome.
Absolutely.
And that's what that latitude was hoping to sort of accommodate.
And I recognise, Mr. Ramsey, that sometimes things when you're dealing with nature don't go as planned, and therefore there needs to be some latitude. But I think that latitude could be built into the annual review by saying, look, we didn't achieve these. These are the reasons why we don't achieve it, but these are our goals for next year. And then if you've missed it twice, then you have got grounds for concern. But it's just thinking about those. I accept there needs to be a degree of latitude because not all trees survive, not all planting takes, not all soil has the right conditions that you want it to achieve its ecological objectives.
So we have a slight concern regarding the possibility of regression under this clause, in the sense that one way in which the County Council and the appellant could agree to resolve difficulties in implementation is to agree that they don't need to be done, and therefore to move backwards from what was intended originally to be achieved. So whilst a sort of non-regression clause might not be something that you'd be sympathetic to, and say we have a concern that this could lead to a sort of gradual erosion of what was originally intended.
It shouldn't. I accept your point. But in terms of perhaps the revisions that we talked about earlier, to understand whether there's any if there are reasonable reasons why there is regression in some areas, but there'll still need to be something done with those areas. That annual review meeting, which identifies the annual review deficiencies, should start to be the first phase of identifying where there's something happening, because that should give the reasons why something's not being done. If it's not being done by year 2, then this is where this clause should kick in, and then you've what I'm trying to say really, there'll be articulation of where that regression's starting, and therefore that's the opportunity for somebody to step in and say, hang on a minute, this is contravening the first bit, which is a plan, because you're not sticking to the plan. I can't be kind of be more explicit than that, but I can't direct the council to do things. But all I can do is to provide a framework that clearly identifies where changes are occurring or things are not being done, and a framework whereby that is reviewed and the reasons for that not being done are agreed. And then the next year, if it's not done again, then there's an enforcement mechanism that can kick in, which we've already talked about, that can deal with that. What I can't deal with, and I don't know how you would reasonably deal with that, is if there is a subtle change to the plan, provides for changes to the plan that moves something completely away from the aspirations of that imp in the first place.
I think
I can see your cautious point. I don't think it would happen because the council's reputational and its whole aspect of its being will be under scrutiny there. But
yes, I suppose there's a legal point which is reassurance that there is that this schedule doesn't provide for the derogation effectively from what was originally agreed as necessary in order to mitigate the impact of developments. And because if it does, then effectively it means that the County Council and CEMEX can renegotiate the terms of the consent annually at the expense of what was considered and what local people and the parish council are expecting to be provided.
So if it assists in this respect to try and bring some, I think, comfort here, in Schedule 5, it moves on.
Which we've not got to yet.
Sorry, which we're not onto yet. But within Schedule 5, when we move on there, we'll see that there is the purposes of the EMEP are set out. And at paragraph 3, it says that the EMEP shall be in place for the duration of the period and in order to achieve the objectives which are then set out there. So any EMEP revisions will still have to comply with the original purposes of the EMEP, which are to ensure the ecology interests. Obviously, we'll come back onto that later, but I hope that gives some comfort.
And are we being assured that the County Council can't decide that that does not need to be the case and would not be challengeable on that by virtue of the construction of this schedule?
Tell me, as I read this then on the basis, because I've not got to 5, there's an EMAP or an environmental management plan. That's a framework, that's agreed. Every year you're starting to incrementally implement the provisions of that. Sometimes you might not achieve it, but there's a mechanism to review it and make sure we achieve it. Is there any provision in here for the whole scale review of that EMP? I'm not suggesting there should be, it's quite the contrary, I'm suggesting there shouldn't.
So, no, not as such. Instead, in Schedule 5, it sets out the basic principles of what it should always seek to achieve. So
that's always there?
It's always there.
And it can't be, I suppose you'd have to have a new agreement then to change that.
Indeed.
That's as best I think I can offer you. So the framework remains constant.
I can foresee a problem, but let me rephrase that. I can see a mechanism by which a problem could arise, in the sense that basically if the parties to the agreement agree that something does not need to be done or is no longer is not purposeful in terms of implementing the original content of the that actually for no third party, in particular the parish council on behalf of local residents, would be able to raise any challenge against that, because the decision about whether or not this was actually needed was basically just between the two parties, and it excluded any third party challenge to that decision.
Is there something in there about the end of the EMP? In other words, what is there to demonstrate the achievement of the objectives that's been achieved at the end of the period?
So it's in place for a period of 30 years following the restoration. Yep. And during that period, it is required to achieve the objectives which are set out including the long-term survival and characteristics of flora and fauna, which are set out. And of course, that is then linked back to the application documents, which set out the position at the beginning. And during that period, we have the review mechanisms of the EMEP during the specified periods to ensure that it's continually reviewed with the objective of achieving those.
Right. Okay. I won't continue you off.
Sorry.
No, I wasn't cutting you off. I was saying, yeah, okay, if I thought something tweaked in my mind. It seems to me that, and whether it's a matter of drafting here, that there's no intention, as I understand it, to deviate from that EMP. It's a framework that applies. And the annual review really should tell you what you've done to achieve the objectives of that and what you need to do. It's not about, correct me if I'm right, it's not about changing it. It's about the things that need to be done that haven't been done. And I think we've somewhere tied ourselves up in language here that suggests that that review is about changing the EMP. But you're not going to change it because that framework sits there all the time. So all you're reviewing actually is the actions that need to be done in the next year to achieve the objectives of that. And if that's your intention, which seems to be what the parish council is suggesting, then it's just a matter of drafting, I think, just to be clear about what is the end game. You're starting with something, you're working through every year to achieve it, you're not intending to differ from it, and at the end of that you can certify you've achieved it. But we've got ourselves somewhere, I think, into some language that says, oh, we can review means change, and I'm not so sure if that's what you really mean.
So it's noted and we'll have a look at it. I think just to clarify, by changes, what's really envisaged is from the ecologist looking at the site and seeing how they can better achieve the objective of ensuring the long-term survival of those features. And so by changes, it might be on-site matters for that can be done better, because it might be betterment, essentially a different way in that it might be, they might have a different strategy that will achieve something better, and then we're looking at a 30-year period, and something that might be considered the right way of doing it right now may be very different in 20, 25, 30 years' time.
So we totally accept that, and I'm sure that is the purpose of this review mechanism, because it might turn out that the way we think is the best way of doing something now is not.
Yep.
And it's absolutely sensible that the parties should have that review mechanism. But if something in the wording to say that it is about potentially finding a better way to achieve the objective, not to agree for the two parties to just basically shrug their shoulders and say, well, that was a good idea, wasn't it? But it's a bit hard, so let's not do it, because that happens, and that should not be permitted.
I think we're all in agreement. I think it's just how you word it.
Yes, I think perhaps we can add. So we'll go away and think about it. But add into Schedule 3, perhaps just clarification that it will be linking through to always achieving those objectives that are there, so that it's clear that there won't be a sort of step back and derogation.
I think that's the reassurance that I think we need, and then just take out some of that latitude around what that review meeting is really all about. It's not about changing things, it's about ensuring things that should have been done are done. Marcel, so you okay with that? All of that? That just take us on to 5 then. I'm not so sure what we need to say about 5, other than the fact that it starts to give us that reassurance, but it needs rethinking a little bit in the light of what we've talked about earlier.
So it would also be appreciated if the 30-year time period of the EMP could be specified and set out as a minimum. I'm not sure if I've just missed this and it's somewhere else, but I haven't been able to find the actual time period.
Apologies, it's in the definitions. It links through. Apologies, I'll just find the reference.
I'm so used to searching in electronic documents, it took me a bit longer.
Time period is not defined.
sorry, it's linked through in the secondary review period is defined to say it means a period of 30 years commencing from the end of the initial review period. So it then links through within that, sorry.
But I think in terms of the scope of the AMP, the scope should also identify the time period that is going to be taken over, because otherwise we are just resorting to a definition that is by virtue of something else. I think the time period should be the essence of the AMP as well.
Can do that, but you're not bulking on that. It's just how it's explained.
So in case it assists, I think it is essentially dealt with in paragraph 5, is it off schedule? Sorry, schedule 1, in that from the EMEP start date until the end of the secondary review period to undertake the process of the annual review of the EMEP adapted procedure. Oh no, so yes, in there,
yep.
It links back, the definition links back through, which means it must be in place until the end of that period. So it is in effect, but perhaps just not clearly stated.
Yeah, I think it's perhaps just needs a definition of the EMP time period, and then you've resolved it then. All right, just on 5 then. This is the one that does bind you in, as you said there, to the what's going to be delivered at the end of that period. Maintenance, management compartments, detailed description of management compartments, detailed description of practical works in each management compartment. I don't have a big issue with that. Of the fact that it just might want to just a recast over, just in light of what we said earlier, but the principles of what that's trying to achieve, where in my role in this, I can't see there's an issue with that. Anybody got any comments on Schedule 5? All right, let's have a look at Schedule 6, completely different topic, HGV routing. I'm going to read this, I think. I hadn't picked up any comments on that. I have on 7, but not on 6. I'm going to read 6. The developer and the owner, on behalf of themselves and their successors, entitle to the site, covenant with the county council as follows. 1.1. That they will require all HGVs travelling to and from the site in connection with the planning permission and the development. Not so sure if they're one of the same, but anyway, it doesn't matter to me. To follow the permitted route. The permitted route is defined. I'll come on to that. That they will not allow HGVs to access the site except in accordance with the permitted route. Just for the avoidance of doubt. The permitted route is in Annex 3, isn't it? Oh, I got that right.
Apologies. The Annex 3 contains the HEV routing plan, which demonstrates it, and permitted route, I believe, is within the definitions.
It is. It is in the definitions. The only thing that probably needs to be done somewhere is to link all of that to Annex 5. Is it Annex 5 or whatever annex it is? Annex 3. The permitted route's defined.
Yes, the definition of permitted route includes reference to the HGV routing plan, which is a definition then links to the relevant annex.
That's Annex 3. Alright, it's only me just saying put Annex 3 in there as well. Then you go straight to Annex 3. Let's go back to what I was saying there then. So you can't access the site except in accordance with that permitted route. That in every contract they enter into with any contractor that requires HGV access to and from the site in connection with the planning permission and the development, they shall include a provision in the contract which which will be binding and instructs contractor to take effect as a warranty to the effect that all contractors' HGVs to the site, travelling to and from the site, must follow the permitted route. If there's a breach, then there's a mechanism here for progressive warnings through to contract termination. Warning first breach, written warning second breach, suspension for 1 week for further breach, and then termination if there's more than 5 breaches. And the only exceptions to that are if delivery is made to a location within the village of Hamble that would necessitate a different route to be taken other than... What's that mean?
So I believe that's in the event that a load were leaving, which was actually going to the village of Hamble, so that they wouldn't have to drive away in the opposite direction to then come back again in terms of efficiency. So they would be allowed to turn towards the village.
So it's delivery of material to be used for construction projects within the village. Maybe,
absolutely.
Maybe it's me that you might want to say that. It's maybe me thinking, because other people looked and thought, what's that mean? I understand what it means. It's not exactly what it says, but I understand what it means. And that's quite reasonable, I think.
Yes, we can clarify the wording there to make it clearer.
The extent that is necessary for HGVs to depart from the pitch route in the event of emergency, that's reasonable. Or to enable the driver to comply with any directions given to him by the police or traffic warden. Do we still have traffic wardens? Never mind. Or to comply with any traffic sign. That's really saying to some extent that you can't supersede the directions of the police or traffic regulation orders or something of that nature, isn't it? As I understand it.
Indeed, sir, that's the intention. If the police were there on a particular occasion because there was an incident and obviously wouldn't want somebody to go toward, the police were directing people away from the incident, it would be that they followed the police's directions. The same with if there were a diversion in place, that they were following that.
We do have some concerns with that in the way that it's worded and such, because what we would consider as preferable, if there is an emergency on Hamble Lane and vehicles can't turn left out, then it would presumably be preferable that they didn't leave the site at all, rather than add to congestion and safety concerns within the village and within the very tight road network there. So I think there's a different way of addressing emergency situations so that the vehicles don't leave the site at all, rather than adding to congestion, adding to an emergency situation by putting HGVs on the network. So that would be our preference.
So if you can assist, I think that actually is covered, because the HGV drivers in 152 have to comply with the directions of the police, and we'll take the point entirely, but it would be up to the police to say stay in the site, and they'll have to comply with that.
It's not possible for an HGV to go through Hamble. It's far too narrow. Such a lane cannot possibly take any traffic up there. The police cannot possibly take anything. So if they can't turn right out of the entrance, they can't get out.
That's probably answered your question.
So they can't come out and then sit there, do a U-turn, go somewhere else.
So I think the point is that the police will be aware of that, and that they will have control in such an exigency, and they will direct.
They might not, because they're not overstaffed. It's impractical. You cannot turn an HGV out of that site and left. There's nowhere to turn around other than the fire station entrance.
I think then what I would say that this only provides for, you can only depart from this plan if instructed by the police or instructed by a traffic regulation order. So the fact that there might be a blockage, you have not been instructed to depart from the plan. So it will be a breach.
Yes, sir, it would.
So I'm not sure that would capture Ms. L's point, that because you've got two scenarios. One is where the police say you cannot use a particular, or you must not. No vehicles.
Can't turn right.
You can't turn right. You can't turn
Yep.
left. You can't do anything. There's an emergency. Everyone stays put.
Yep.
Another scenario is there's an emergency here, but we frankly don't care what you do so long as you don't affect our emergency. And that's the situation I think that the residents are concerned about, which is that actually the police are managing an emergency, which means that the vehicles can't use the permitted route. But the police are not going to say, we're going to enforce a Section 106 agreement between you and the county council.
No.
That's not,
No, I
that's not
appreciate
their
that.
business.
If I'm being honest, I think it's covered. And maybe it's just the wording, because I think you can only turn right, full stop. The only times that you can't turn right is if an officer of the law or a traffic diversion order, which will have taken into account HGV routines and weights, instructs you to do something else. And those are powers that are beyond us. That's the way of the world. We're stuck with those powers. So it seems to me there is no provision whatsoever without breaching this agreement for you to turn left, other than you are forcibly instructed by the law to turn left, or there's a traffic regulation order. Perhaps the issue is, to some extent, that in those circumstances you have the choice to turn left, if instructed by the law, or you have a holding area within the site where vehicles park until at such time they can turn right.
Sorry, I don't think I'm being clear enough. It's not that we don't want you going through the village. You physically won't get a truck through. There's a chicane.
Yep.
So,
There's no point in saying anything about turning left because you can't go anywhere. You can't turn around if you do go left.
so to assist, we are not actually referencing turning left. What we'll do is we fully understand the concerns. If we may, we'll have a look at the provision and with the county council and just see if we can tighten it a little so that those concerns are picked up.
You wouldn't turn left by a traffic regulation order because a traffic regulation order would prohibit you anyway. I think the concerns are covered. I think it's the way it's articulated that's the issue.
I mean, I think so. It would be accepted that the police are not, who know the local area, are not likely to instruct someone to do something they can't physically do, and that
Stopping
therefore
the
does
site.
pick up the resident's point.
Yep.
But it should left turn should only be permitted if the police, for some reason that none of us can imagine, instruct that should happen. And in those circumstances, well, we all have to comply.
Yep.
But in no other circumstances should left turns be permitted.
The only other circumstance could be a traffic regulation order, but it's not going to do it anyway because you can't do it. So I think you're covered.
So, if I may, there is a holding area within the site as well.
Then
So
you're
it's not a practical problem for the facility.
You could even reinforce it by saying in such circumstances where vehicles can't leave the site, they shall park up in the holding area.
It's a concession on Cemex's part, so because I can't do it anyway.
Yeah, absolutely. Yep. All right, I think a little bit of work on that, we can make that tighter. We need to push on because we've got an hour then left for the conditions. Just in Schedule 7, I don't have a problem with Schedule 7, but my brain can't understand why we need 1 and 2. And I can't understand what's the difference between 1 and 2.
If I may say, it's a convention in drafting these agreements is that you express the obligation positively and negatively just to give yourself the best possible opportunity of enforcing through an application potentially for a positive injunction or a restrictive injunction.
It seems crazy to me, but that's fine.
We are in the hands of the county council. So
Absolutely, yep. You had a comment to make? Yes, oh, yep.
Sorry, I made a comment on this on Tuesday regarding this by the council. What it says here is that the resident can't commit to the amount of paying. What about actually doing works?
Let's come on to that in a minute.
My other point was that is the 500,000 amount.
I can't discuss that because that's the matter that's been agreed with the county council it's not for me to dispute the.
I asked whether the county council could explain why 500,000 is enough when on the average of then 200 metres of road and originally agreed as to 200 metres. Is that going to be looked into?
Not by me, and I'm not being disrespectful there or dismissive. It's just the fact that the county council, as highway authority, has identified to me through a self-compliance statement that this is the value of the works. This is the value of the. These are the works. This is the value of the work that needs to be done. I've got. Bear in mind, they're the highway authority. I've got no evidence to suggest that there's something wrong with that because it's bound into a self-compliance statement. So the fact that there might be some doubt regarding the value of the work, when I've got certification from the county council that won't be the case, unfortunately I have to take that on the basis of the documents that I'm provided. You will have a view, but I'm not going to debate, and it's not for the prisoner's inquiry to debate the value of those works. I can't do that. It's beyond my powers to do that. But I recognise your concerns. I recognise that you think the works have been undervalued. I can't. Well, there is, because you've got a session in a few weeks' time talking about highway issues. So that session will be able to deal with the mitigation measures. So that's the way that you would have a discussion about the adequacy of those mitigation measures and whether or not there is sufficient provision to ensure they're implemented.
And the timing of those mitigation measures, here all the entities pay.
Yep. Yep. So this provides a mechanism for payment for those mitigation measures. Whether or not it's enough, well, there will be another discussion in the inquiry when we talk about highway issues, whether indeed that is the case. The mechanism's fine as far as I can see. The value might be subject to some discussion in the inquiry. So, you okay with that? Right, so you can't commence the development until you've paid, the positive and the negative. Schedule 8.
Sorry, sir. We've got. I know we're against time and everything, but there are a few things that I'm not sure how my concerns about timetable delivery have been met by Schedule 7 or by the descriptions of the transport contribution. There is no reference to agreeing a timetable before development starts with the county council.
Yeah, just a minute. Yes, no, I can carry on.
You know, that there's no merit in terms of ensuring that the works, the mitigation provided through this Section 106 are delivered before development starts. So essentially, through this agreement, as long as CEMEX pays the money, they can start on site without any of the enhancements and mitigation provided to transport.
All right.
That was my reading. So that's why I think right now it's deficient.
Let's come back to the developer then, because there are other planning conditions that link into that. And what I'm not sure about is not all of those mitigation works need to be done at day one, as I understand it. Some of them are incremental, have got to be done by certain things need to be done, particularly, but all in place when you start putting the vehicles out. The 106 does seem light on identifying the implementation mechanism. How do we resolve that concern? It's not asking you to do anything that you're not agreeing to do. It's just how you've articulated that or not articulated that, I think, is the issue. Some of that is bound in the planning conditions, and I know that. But I think there's right to be some concern that there's a payment, but this is silent on the mechanism.
So I'm looking at Mr. Hammond. This is a typical example, isn't it, of a conditions and Section 106 agreement and making sure it all comes together. Can I hand over to Mr. Hammond, unfairly pushing it in his direction?
Of course. This might be something I need to take away for instruction on from my highways client, just so I understand the full detail of when any particular measure needs to be in place.
It's a sequence of the events that implements the highway works that's identified as a consequence of the contribution.
Correct.
And I don't think anybody in any shape or form is suggesting this. We're not going to do that. It's just that it's not articulated robustly enough, I think, within the 106. I know the planning conditions capture that. You could argue, well, if that's everything that's agreed, that's what the principle of all this is, but it's not explicit.
And sorry, Mr. Hammond. So if it will assist, we will mention this to our highways consultant, who is speaking with the Royal Six Parties highways consultant, and hopefully we can get some clarity with the views and practicalities as well.
Yeah, because what we could do then is, I'm sure within evidence somewhere, if it's probably from the Royal Six Party, there'll be something about the implementation and mitigation of the mitigation measures. So hopefully that would feed into your concerns that you probably will be. You may articulate during the course of discussions in June that are those mitigation measures properly secured.
I'm sure June will be a fantastic time for transport and highway mitigation discussion.
You need to get out more.
Yeah. I would normally expect in a drafting of Section 106 for highway mitigation like this, for things that are necessary to deliver the development and delivered through a Section 106 agreement to be clearly identified through the schedule, and if not being dealt with directly by the appellant, then there'd be an agreed timetable of works, so at least the appellant knew when those works would be delivered through the county council. So also providing reassurance to the county that they will be delivering them on time, along with the other notifications of implementation that triggers all of these works to take place. My notes on the highways contributions and transport matters had all been in one, so I have got some concerns, and it's going back to the definition, that this will need to change following the transport evidence. It is far too brief and does not have enough detail in it in regard to the level of contribution. But rather than go down that today, it's just an identification that it will need to say more. It will need to confirm the length of footpath that needs to be improved, how it can be improved.
Stop the footpath. Yep.
Yeah.
All right.
So just, if I may, just echo those points on behalf of the parish council. Those of us have, over the years, the misery.
The path.
On behalf of the parish council.
Oh, sorry, I thought you said on behalf of the path. Sorry, I do apologise.
From residents' point of view, you know, many of us around this table have had the misery of dealing with Section 106 agreements for many years, and we know what the limitations are. But the bottom line from the is that if the obligation simply requires the passing over of the money to the county council, then the appellants discharged their obligation. That's great. But the local community wants to see the works which the county council says are necessary in mitigation secured, and not risk that money simply sitting with the county council waiting for some time that they consider convenient to get the works done.
Yeah, there used to be a schedule that says what you're going to do, when you're going to do it, how much does it cost. You've got the costings for each individual component. What's not in here is when that's done. So I know what the components are because they're in the sale schedule, but I don't have the implementation time frame in here.
Yeah, thank you, sir. Yes, I've heard the discussion, and your preferences are, as I say, I need to take it away, take instructions on what we can do there.
Okay. I'm going to move on from that very quickly now. 8, you've probably got to some extent similar issues regarding timescale with 8. So you construct a permissive path. All right, we might go back to the planning conditions about when that has to be constructed, but as that's worded, it doesn't say when we construct it. You're going to construct it to the standard that's in the countryside service path servicing, but that needs to be revisited in light of the discussion we've had on path width. And so I'm not going to get into any debate, I don't think, on that, because I think that requires similar kind of discussion to what we've just had.
Sorry, sir, just to point out, it does say prior to an extraction. That was when it was envisaged that it would be constructed. So we would put in place a tree protection and then construct the bunds and put the fence in place, and then the path would be opened.
Yeah, okay. Yep, no problem. Needs revisiting anyway.
So we will be looking at that provision as well in light of our earlier conversation.
Schedule 9, there can't be any real disagreement with Schedule 9. And the annexes, well, they're the plans that refer to there shouldn't be any issue with those plans.
I do have an issue, unfortunately, with the, I didn't manage to say it in relation to the...
Well, there is an issue. I can see it already.
The routing plan. Currently, if that was given to this is the document that will be given partly to a HGV company to identify the routing that they must follow. I think there has to be more explicit discussions on here in terms of there should be a no entry in terms of Hamble Lane South. There should be more explicit arrangements, and I would normally appreciate if the routing plan actually included details of where the vehicles went in and actually where they left the site as well, in terms of counting, in terms of identifying movements, that sort of thing. I know it's going off tangent
the conditions do some of that.
Yeah, but for a routing plan to be given to a HGV contractor so that they know what they have to do, it would be beneficial to have that information and have something more explicit. Because right now, as soon as all I see is this is the site entrance plan with a yellow highlight.
You will have your arrangements for notification to contractors on routing plans. There's no reason why you can't incorporate some of those in this, is there?
Yes, I quite understand. It's one of those quite unhelpful plans with a red line and small details in it. We will have another look. We're obviously in also the hands of the County Council. Mr. Hammond will want to talk with the highway people, but we'll get together and resolve those issues.
Sorry, just so it wasn't quite clear what exactly you wanted to say, just to make sure we cover that.
I think it's the fact that the routing plan's is a little bit deficient in what's the expectations of the contractor in meeting obligations, and whether the site is adequately signed in terms of providing some reassurance to ensure that the routing plan can be followed. So I think it's the information that's passed to the contractors, what's their obligations and expectations. So you kind of, within there, the contractor shall be provided with the routing plan, which shall comprise of all these obligations. You'll also be notified of the implications of not complying with that, and the routing plan for its effectiveness should also include adequate signage that says you turn right, you don't come in here, whatever it is. I think that's what you're really looking for, something of that nature.
Ideally, right now, the Section 106 or the routing plan identifies any course of action for those HGV drivers that are a little bit blind and miss the site entrance.
Yep.
What do? Where there should be a process by which they follow to not cause issue. And
well, the process is it's a breach. The written warning. Eventually.
But how do they get into the site? Then, if they go past the entrance, what is the procedure to get them into the site?
Some of this we might be getting into traffic regulation order, and we can't deal with that. I can have a look at it.
Yes, this is, I think, more appropriately dealt with during the Transport Highways session in June.
Yep, I accept your point. My only concern on Annex 4, and I probably know why you've done this, but it's not the right revision plan. You've got revision B, and I've asked to be considered revision D.
Apologies, sir. We'll correct it.
We're only human. Your mind's probably like mine. It's going around all over the place. Okay.
We'll review the position.
All right. It's a basis, it's a start, but we need to do a fair bit of work. We're not going to be able to have another roundtable session on that. We just don't have enough time. But what we can do is ensure that the revision to this are passed to there's no reason why it can't go on the website. There's no reason why the parish council can't be sent a copy. The Rule 6 party will get a copy anyway. But all I can suggest is that we're going to have a revised draft, it's got to go do the rounds. I'll put something out next week to say, well, can we have comments on that by a certain time? And then at some point when we resume in June, we might have to revisit elements of it, we might not. We'll just need a little bit of a quick mop-up discussion about the Section 106.
Yes, so that's understood. And, we'll fit in with your timetable.
Right, pull out very quickly the planning conditions.
Sorry, sir, if I could just start by just identifying there are conflicts between the Section 106 definitions and the planning conditions.
Tell me what those conflicts are. Don't tell me there's conflicts. Tell me where they are. Well, don't now. I'm going to go through each one sequentially. Otherwise, number one, timescale. Nobody can dispute that one. 2, mineral extraction and waste recovery, uncontaminated minerals shall cease and shall restore. 14 years from date mineral extraction commences. Right, my comment on that was that's a time trigger on commencement. We had evidence that some sites do get mothballed. If they were to do the preliminary works, not do extraction, and mothball the site, what happens? The permission can go on 30 years, 40 years. Can't go on beyond much more than that, but so my concern was it probably needs to have something in there because of community concerns that in any event there's a backstop somewhere, because they could do all the preliminaries, not extract and therefore not invoke that, and sit there.
Yeah, take your point, sir. Thank you. I'll take that away and we will look at a redrafting of the wording of that condition.
That's me just saying that there is a mechanism that you can go on 14 years if we're not careful.
That was our concern, and maybe a way of addressing that through condition 1 is adding a note of commencement requirement, and that relates to what's been done and also then relates then to extraction works.
All right, you can have a look at that.
Sorry, just to come in on that, there is condition 43 which says, should works on any part of the site subject to this permission for any reason cease to operate for a period of more than 24 months, a revised restoration scheme should be submitted. So it may be that we just need to tweak the wording on that potentially.
I think that's just the restoration scheme, whereas this is about the fundamental implementation.
All right, let's look at that when we get to it then, but there's a concern there that either needs to be dealt with in 1, 2 or 43. 43. Prior notification shall be given intention to start dates. This is what it comes back to what we've been talking about earlier. Construction of the Belmouth access onto Hamble Lane, commencement of the stripping of the soils, mineral extraction.
Our first thoughts was that 7 days seemed really quite short in order to pre-warn the county and get everything sorted and know that works were going to start and have everything in a line, and that really needed to be revised, and that under B, when it refers to commencement, we want commencement of each stage of works related to stripping, giving the phased nature of the site.
Just on notification, the County Highway Authority will already know anyway, because you'll do a section 278 or wherever it is now under the Highways Act agreement, so they'll know. But if your concern is about is it adequate notification, then 21 days wouldn't be unreasonable. I wouldn't go beyond that, to be honest.
I'm happy to amend the condition if the appellant is on that.
We'd ask for 21 days, sir.
That's okay. But the Highway Authority will already know about the construction of the Belmouth access because of the agreements they're going to have to enter into under the Highways Act. That's not before me anyway. And then the commencement of soil stripping operation, mineral extraction and infill in phase 1-4 and the plant site.
I mean, those phases were chosen because it's kind of the start, the middle and the end rather than every single phase.
I personally didn't have a big issue with those, but there is a concern. I'm not going to try and resolve that now because I don't have a big issue, but maybe it's a matter of dialogue as to whether or not there's some concerns that need to be revisited. I'm going to go on to 4, site operations. It's contact information for the operator in relation to operational impacts in the event of emergency. The principle of that's fine, the mechanism's not, because they could put on there their office address or office telephone number, which is closed, but they've complied with the condition. It's a 24-hour emergency contact number that's needed. You do it anyway. You're going to have to do it under the Mines and Quarries Act and all everything else. You're going to have to do that anyway.
So could we have something a bit more modern as well, than on top of displayed at the site entrance? Perhaps something that provides a landing page on an appropriate website, so that something that displays in a form that residents are actually going to find a bit more accessible. So there's one place they know they can go to get that information.
I'm going to just talk on behalf of Helen and Emma, hopefully we'll agree with, but that is a mechanism that CEMEX already has in place for most of its sites, I understand, in terms of having site-based websites with that information on there. Is that correct?
I'm not sure, but I'll definitely check that. I'm sure it's something we can do, is have a web page with those details. That'd be fine.
I'm sure it's something that, as a good neighbour, CEMEX would want to do, but I don't see that it is problematic, sir, for you to include something to that effect in the condition.
Yeah, no, if you can think of something, I'm not going to enforce it because I'm starting to think about the test of a planning condition and where we're starting to stray into other aspects of legislation, but I don't have a problem. We can do that.
So I'm no lawyer, but if the purpose of the condition is to enable people to gain access to that information, it seems sensible to give them access to that information in a way that they will actually consume.
I agree with you. What I'm saying is that from my perspective, sat here, I'm not going to make a big deal about it, but I think the parties agreed to deal with it. All right. 5, site environmental management plan. I'll tell you some of my issues in this and you can tell me some of your issues in this. The SEM should cover matters details of the areas subject to activity. I'm not so sure how you do that. Well, what is activity? So think about it. Commitment that all vehicles and plant machinery operated within the site shall be maintained in accordance with the manufacturer's specification. That's not enforceable unless you're going to ask for the maintenance records and compare those with the manufacturer's specification. I know what you're trying to achieve, but it doesn't meet the test. As indeed G is a starting point, but it limits you to Euro 6 engines forever. This is more about climate change and reducing emissions and whether or not we need to think about being more imaginative in that condition. Specification for excavators on the site, the yellow. That's my spec, met it. I'm not so sure what you're trying to achieve by virtue of that in any event. How waste generated on the site will be managed. What waste? The inert waste that's been imported, the waste generated from plant and machinery maintenance, the waste in the waste paper bin in the office. I don't know what you mean. Provision for emergency vehicles. We're going to have an ambulance, a fire engine, and a police car on site. It's not what you mean, but it's not what it says. Details of groundwater monitoring. Provide the details, but I couldn't see an implementation clause to that. And then the other thing that that jumped out of me, details of how sediment, concrete or other debris may be accidentally released during construction. And I've put this construction of what? A house? This is, I think these are environmental health standard conditions that's come from somewhere and not thought about how they relate to the development.
Yeah, take your point, Sarah. I think they need to be much more precise, so we'll take that away and look at that for you.
There's quite a review, I think, on those, if I'm being honest with you. I don't know if they've got other things that you've picked up.
I've got a few more to add to the list. I agree completely with the comments you've made, but under L, it says the design and erection of site signage on the Hall Road indicating no left turns, turning. this, as worded, is unacceptable, as it sort of implies that no one will queue on the road. They'll all queue, or they're not allowed to queue within the site. They have to queue on the road. I got that the right way. So it says, it indicates that queuing on the Hall Road will be prevented, but not onto or off Hamble Lane. So that's causing the issues that we've been talking about.
Yeah.
So I think that needs rewording, and possibly through the routing plan explained how that's supposed to take place.
I take your point. It's, yeah.
At N, it refers to the means of sewerage and the phase and delivery of the surface water disposal scheme. But again, that should be phased delivery to be accurate.
I'm not so sure whether that's relating to the extraction or the plant and office area.
In relation to the foul sewage comment we were just talking about, it was something that came via Southern Water, so I will clarify that.
I think there's a difference here. I think this is relating to the administration officers.
Yeah.
This condition, which is
So
a
again,
standard
if we
Southern
could just
Water
have
condition,
clarification on those and a little bit of
which is completely
specification.
different to the other discharges that we went through in the hydrology issues, and I think that's not clear.
And then at P, you rightly identified what construction, but I also want to know what water are we talking about here? Are we talking about water within the extraction areas? Are we talking about water within the SUDS areas, the attenuation areas? Because at the end of the day, this purpose is to prevent materials getting into the water, concrete, sand, gravel, whatever, and affecting the SSSI through discharge. So clarification of what water it refers to would be appreciated.
I'll take that point and we'll look to amend that.
And then at R, I don't understand, or rather we don't understand the groundwater level monitoring here, why there isn't a further scheme for the groundwater monitoring, why it is only on one boundary, and why it's only after 3 months of a certain period of time. So would like that completely reviewed, really, and
It's wider than that, isn't it? Because
yeah,
what do you do with it? What do you do with that information? What are you doing it for?
Yeah, condition 24 also cross-references certain things.
Let's get to 24. Don't jump, otherwise.
But I think this has
with
to
40
be,
minutes.
Yeah, this has to be corrected, really. And the 3 month period seems like a very long time. It should be a 1 month period.
I think my issue is that you put the boreholes in, you monitor the boreholes, so what? What do you do with that information? What's the relevancy? What you're trying to achieve by the monitoring? And if you are trying to achieve it, what is it you do if it's telling you something that I don't know?
Yeah, and take that point back. I'll consult with the LFA in relation to that because I think that's where that came from.
And then overall, it's whether this condition should have any cross-relevance at all to the EMP in the section 106.
Well, I wouldn't expect that referring to a section 106, but the need to build a line.
Resulting
That's
document.
a discussion we had.
Yeah.
I'm not going to refer a condition to a section 106 agreement.
But the resulting
it could
plan.
change. Yeah.
Yeah.
But, so, all right, stockpiles 3 meters height. I ain't got an issue with that. Notwithstanding the approved phasing timetable, extraction in mineral phase 5, extraction of mineral in phase 5 shall not begin until phase 2 has been restored.
It's just whether there needs to be a notice provided at that time.
Well, there are provisions later on, I think, for notices.
So I think that's covered by one of the other conditions.
Okay. And then, sorry, just regarding condition 6 and the height of the stockpiles, is whether the condition also needs to refer to ground levels?
Above approved ground levels. Should it say existing? No, it's not existing because you're changing the ground levels for the stockpile area. Is there a level plan of the stockpile area?
There is, I believe, isn't there, Emma?
So you could type back into that plan that it shan't be 3 metres any higher than the 3 metres as specified on that, above the ground level specified on that plan. That would address it. Hours of working.
There's some conflict here with the section 106. So in the definition for working days in the section 106, it is Monday to Friday, whereas the hours of working and other hours of conditions, we include Saturday. The Saturday is just not acceptable, particularly at 7 a.m.
If I may, sir, to clarify on the section 106, the definition of working days is only to define that it's essentially not bank holidays for the purposes of giving notice. Nothing else in the section 106 refers back to working.
Yep, I understand that. Yep. So it's not prejudicing that. Yep.
But on the other hand, if even taking that as the explanation, we believe that 7 a.m. on a Saturday is still a very early time for a weekend, when I think it's standard that, you know, if this was to go through planning within Eastleigh, for example, they don't allow anything to start before 8 a.m.
So much for the county council. I can only deal with what's being put to me. I think the point's made. I'm not going to stipulate it. It's not my job to stipulate that in terms of, some environmental health people have commented on that anyway.
Just to point out that I think those are the hours that were tested through all the noise documents in the application.
I'll leave that one with you. 9. No HGV goods vehicles shall. I think I put a point there. Should that be in this section 106 in terms of some of those routing plans? There's nothing wrong with it here in the condition, but it's kind of forcing the condition enforceability, and you could reinforce that by the contractual obligation placed on the haulage contractor that it shouldn't be arriving at those times, and it could also be subject to some of the default arrangements that's in that 106. Because if not, you're going to be sat there every day in those hours. So there's a enforceable condition.
It was also a suggestion that referred to leaving and entering the site.
It was never the intention to prevent them entering, otherwise you'd get queuing
don't stop
on Hamble
entering,
Lane.
does it? Don't stop entering in those hours. 20 lorries could enter in those hours, wouldn't it? Yeah.
That was the intention, to let them enter, because otherwise you'd get queuing on Hamble Lane. That's always been the intention. The intention was to stop them leaving between those hours.
So that means that you need to into the highways evidence.
I know we're going into highways here in terms of everything that's going to be discussed in June, but one of the reasons that I saw this condition being specifically identified for these times of day was to deal with movements to the school. Okay, so I think the reason needs to refer to that. It can't just be because of residential amenity and highway safety. It needs to refer to the movement of children, pedestrians and cyclists associated with the school.
Yeah, I'm not going to get too much into the reasons.
That's fine. But then equally,
for me.
The times that are proposed give 5 minutes at this point in time for all children to get out of one of the schools.
45 minutes.
Yeah. Is it the it's 2:30 to 3:30, whereas one of the times closes at 35 or something. So they have 5 minutes. So there's a 5-minute leeway.
So you're saying there's a conflict with the school closing times?
Yeah.
Just to point out, I mean, we're getting into highways evidence a bit here, but these times were based on pedestrian and cycle surveys that were undertaken, so they reflect the peak pedestrian cycle movements along that section of Hamble Lane to try and stop HGVs coming out of the site during those peak times. So that this is based on surveys that were conducted.
So these are relevant to peak traffic flows as opposed to school opening hours, but there is some degree of correlation, but not entirely.
Peak pedestrian flows rather than traffic flows. So the walking and cycling movements were measured. Yeah.
What I'm going to suggest is we'll pick that up in discussions on the highways matters.
Yeah, because the Highway Authority response of no objection required this to be 8 till 9 and 2:30 till 3:30. So it hasn't met the requested
They did change their mind on that because I think there was a conflict on what they'd originally said. They'd said two different things in different places, I think, and they've subsequently agreed the 45 minutes.
All right, it's a matter that needs further discussion, I think, and probably leave it at that. We need to move on pretty sharp. Maintenance. Anybody got an issue with maintenance times?
Why do they have to go on longer?
Soil management and contamination. Soil management plan prior to stripping, submitted agreed. Shall include details of soil management procedures. I'm not so sure if that needs further explanation. How the topsoil and subsoil shall be stripped and to be excavated will be stored separately before operation commences. So you've got a plan that's showing some of that anyway. How topsoil shall only be handled when dry friable. One of the things that I'd kind of added is that the bunds that it's placed in should be seeded and managed. Details on the thickness and quality of top. Right, this is what I got. More detail on the thickness and quality of the topsoil and subsoil used and the method of soil handling and spreading. That's when we get into the restoration phase. And I'm not so sure whether that's precise. More detail on the thickness and quality of subsoil and topsoil. I don't know what you mean by thickness is easy. I don't know what you mean by quality and how you define quality.
That's fine, so I'll take that away and have a look at that.
But there is a restoration plan that you should be defining somewhere that this is a subsoil area. It does. And this is topsoil. How the ripping of any compacted layers and final cover to ensure adequate drainage and aeration, such ripping to take place before the placing of topsoil. Measures to be taken to drain the restored land. That's going to catch with a drainage strategy, isn't it?
Take your point.
That needs a little bit of work, I think, just to have a think about the logical steps of when you lift soil, what do you do, how do you store it, how do you maintain its integrity while you're storing it, how do you pick it back up and put it back And there's loads of.
Yeah, we'll look at the advice we've received from consultees on that as well. So thank you.
12 can't be an issue. No export topsoil and subsoil from the site. 13 is dealing with any unexpected contaminated land. As is 14. That shouldn't be really an issue. 15, I struggle with 15. Only a little bit I struggle with because I'm thinking as how much of this is permit.
Yeah, it is an overlap with the permit. This condition, certainly the first part, also relates to helping the Minerals and Waste Policy team monitor this type of issue. So.
My issue primarily was with the second paragraph.
Okay.
How do you know? Prior to the importation, all construction, demolition, excavation waste materials capable of producing high quality recycled and secondary aggregates shall have been removed. How do you know?
Yeah, I know. So that again has come from the planning policy team. So I think that relates back to the permitting point that you've made. So I think we can probably relook at that.
That's not enforceable, is it?
Yeah.
Because it means you're going to have to go at the source of every load to ensure what's going in that lorry meets that requirement. Because once it's tipped on site, you haven't got a clue what's there.
Agreed.
In terms of meeting that.
Agreed, sir. We will look at that one.
A copy of the submitted waste returns. What are you going to do with them?
So that is.
Why is it your business, not the Environment Agency's?
Again, that is something that quite rightfully so you've mentioned that it is related to the permitting. What we find as a Minerals and Waste Planning Authority, that's very useful for us to help monitor, particularly when we would have a liaison panel in place. And so we would only request them should that be needed, and we would be reporting some of that stuff through the liaison panel as required.
So what are you going to, in terms of planning, relevant to planning, what are you going to do with that?
Our enforcement team use it, but I take your point, so I will take that away.
16, no burning of any waste on site. No burning. You can burn anything else, but you can't burn waste. All right, highways. Traffic management plan. This is coming back to the matters linked in the section 106. And it deals with the lorry routing as well as provision to remove mud vehicles from the public highway. The aspirations of all that I'm comfortable with, but we probably just need to revisit that in the light of discussions on the Section 106 to ensure that there's no conflict and tie-up. 16, prior to commencement development plans, in particular showing the detailed proposals for the site access work, shall be submitted to improved in writing. Yeah, that's fine, you'll get them anyway.
Sorry, this is just one I raised. I mean, no issue with it really. It's just whether that's duplication, because we've already provided a plan of the access as part of the application, which is listed in the plan's condition, which is quite detailed. Then we will need to submit even more detailed plans to the Highways Authority as part of the Section 278. So it's just whether it's necessary to also resubmit more plans to the Planning Authority. But it's something
It's not, is it?
I didn't think it was.
Are you going to revise the access drawings?
No.
And they're already bound in by the conditions on the plans?
Yeah.
It's not necessary?
It was included on the request of the Highway Authority, but I take the point.
In any event, you've got...
We quite like this condition in terms of providing certainty of the works and certainty of the timetable.
Yeah.
We were going to ask that the pedestrian and cycle mitigation be also shown in relation to the site access, so that then it would be different to the site access condition.
It can't be, because if they can only... I hear what you're saying, but it's not necessary, because I think that the site access plan already binds it. You can't change the site access plan, it's there, and that's in the condition later. So, what I mentioned, the test of conditions, whether it's necessary. You could argue it's belt and braces, but it's not necessary. So I'm kind of saying, if you do it, you do it. If you didn't, you don't. And I'm not bothered either way, because it's bound in. But I take your point. If you want to leave it, you can leave it, but equally, it's not necessary. 19 is the vehicle movement numbers.
So this is another conflict with the Section 106. In the Section 106 definitions, a HGV is recognised as being a vehicle that is 3.5 tonnes.
Above.
And in this description, it refers to 7.5 tonnes. So in terms of HGV movements, it is loaded and unloaded vehicles that contribute to this. So again, the definitions aren't consistent.
These are vehicles associated with the removal of sand and gravel and the importation of inert material, which are different to some other vehicles that might be delivering parts, spares, and other matters which are still bound in by the Section 1. All vehicles are bound in by the Section 106 agreement. This is specifically about those vehicles. We maybe just need to have a think about that to see if there's any distinction there. I'm gonna get myself into knots here if we're not careful about evidence next week.
It might be something that we deal with in highways.
We better deal with it next week.
To be honest.
I'm going to get myself into knots there.
But as part of this condition as well, and again it's about highways and probably evidence, but how are they going to manage this number? How are they going to count the HGV movements? So I would have asked for rewording of this so that a scheme to ensure a daily record of HGV movements, so that could be approved by the Mineral Planning Authority, and thereafter a record is available.
I don't have a problem with the record, because that is something, I've read something about that somewhere else.
Yeah, I think
The
it'd be
record
covered
and
by the
vehicle movement.
construction traffic management plan issues, but I think Emma would.
I was just going to say it's completely normal for us to count all our vehicles in and out of sites. It normally happens at the weighbridge, because
Weighbridge,
when they
right,
come in, they have to come to the weighbridge office, and that's where the records are kept.
They're there. You just need to put it in the condition, perhaps, that, and I understand why you need that, because that's the only way you can demonstrate enforcement. All right, let's go on to 20. No excavation materials shall take place until the first 20 metres of the all road measured from the highway has been surfaced. What I put in there is that it's too late, because they can bring loads of plant in, they can bring building materials in, they can start to strip the soil, they can do all sorts of things before that kicks in. and therefore they don't even have to construct the access beyond anywhere other than put the bell mouths in to comply with Section 278. So it's kind of me saying that needs to be tighter.
Yeah, I agree. That's a standing condition that's come from the Highway Authority, but we can look into
Yeah, the
amend
Planning
that.
Authority, stand up to them. Not having it. It doesn't meet the test of conditions.
I agree, sir.
I said that to lots of authorities because you just repeat what a consultee says to you without actually looking, is it relevant to development, does it meet the tests? We do it to get rid of them. I know I've done it myself. But when you look at it and call it a day, you think, oh, you can't do that.
Take your point. Thank you.
That's not tight enough.
No, I would also say more than the haul road needs to be provided. You know, we've been talking about HGV storage areas, as you say, plant, but where's the wheel cleaning going to be happening? And also the weighbridge, you know, in terms of getting before the excavation of minerals, we're going to have lots of vehicles that are dealing with soils and other materials on site that will need to be dealt with. So I think there's more than the haul road that needs to be provided.
You need to have a think about that one. I'm sure if it were me, I would have said no development beyond works to construct the access and the first 20 metres shall occur until you've done that. But it's not me.
We will discuss that, sir, with the county council.
Bird hazard management plan, shouldn't have a problem with that. Protection of network rail assets, oh dear. Right. My only comment on that is network rail might not be called network rail, so it needs to have something in there about their success in tiles. It might be GB rail, but I understand. They're not. I sympathise with you with that one, and I'll leave it at that. Specification for the fill material. Prior to infilling the Dumont battery, information will be submitted to improve your iPad. In other words, was to confirm specification of fill material. The submitted details shall include the technical summary highlighting changes to design from that approved in the FRA. Information on the proposed fill material demonstrate permeability evidence, demonstrate infiltration rates. We know what that permeability attainment is, don't we? We had that discussion this week. Technical assessment at the start. Oh, right. You probably need to have a think about this condition in the light of what we discussed the last week. I'm not going to go over it, but this might be tying to things that you've said differently and pushing in a direction that's maybe not what you've said in the hydrological information.
Thank you, sir. That is a good point, and we will look at it in conjunction with the county council as well.
This needs a look at.
Yeah, this and the next condition.
The next one is primarily of the surface, but it's the same issue, I think, because we know some of that.
We've tied them together.
Yep. Right. Okay. And again, this is the point about repetition, I think.
Yeah, it was just that obviously we agree with the need for these detailed drainage plans, but it was the combination of 24, 25 and 26 would mean 15 separate submissions.
Yep.
And I mean, never been asked to do so many submissions before, notwithstanding the need for them. It was just whether the wording could maybe reflect that it's acceptable to submit more than one phase at a time or that kind of thing to reduce the number of submissions.
Whereas we're actually supportive of the different phasing, and that, you know, after you've done one phase, you may make mistakes and you may have to do the drainage a different way in the second phase. So I think the purpose of the condition is to allow the phasing of the drainage scheme and to allow change, which we support actually. And I don't agree that actually having 3 conditions for drainage means 3 submissions. You discharge them all at the same time, or you discharge them at the appropriate time. in terms of phasing. So I don't agree that they ought to be reduced in scope, but I think there is a way of making them more effective.
It means 15 submissions at the moment, because we have to do one for each phase. So it's just whether that could be reduced.
I think you need to just have a look at this, because in theory you shouldn't be changing the drainage scheme from what you already agreed, and that's going to be approved anyway in that sense. So this is really about implementing on each phase the incremental bits of that drainage scheme. It needs a look at anyway, because of this issue about what we've been discussing these last few days. But I take your point that I understand the reasons why you'd like to see that, but equally I'm kind of thinking of the test of conditions. Is it needed and is it reasonable in that sense? I think there is some more drafting that could achieve all objectives here, without having to specify in each individual condition. But before you start that drafting, I think you need to go back to the condition number, whatever it was that I mentioned, that said this needs a look at.
We were also going to request for clarification of the phases as they go through. Verification, sorry, in terms of the delivery of each drainage scheme.
It's a synchronisation between the phasing plan and the drainage plan. And that needs to be clear, doesn't it, I think? There shouldn't be any ambiguity between what are the phases. Is this the extraction phase, or is it the drainage phase, or is it? We need to be just a little bit clear about that. 27, I bet that come from sun and water.
Just making my way down to it, sir, sorry.
Yeah,
Indeed it did.
I'm not going to say anything more on that one. 28 came from
Environment Agency.
The only thing I would say on that is, if you're going to protect them, you need to know how you're protecting them. You need to ensure those protection works are implemented. It's an imprecise condition, because you would require a scheme to demonstrate how any public sewers will be protected during the course. Those works shall remain in place throughout, and there needs to be some kind of monitoring arrangement, and then there needs to be some kind of removal arrangement. So the condition as worded it's not right.
Take your point, sir. They'll take that one away.
Storing, that's at 29 is a standard facility, a standard condition about storing oils and materials. I'm not going to argue with that one. Archaeology. Has anybody got any issues with that one?
Just it probably needs to be phased.
You could have worded it better, but I'm not. A phased approach of archaeological survey. I'm not so sure what you want in there. Following the completion of archaeological field, a report shall be provided by the applicant. I'm not going to. The field work is not necessarily defined as to what that means. That's probably come from the county archaeologist team. And my only advice really is to, when you get these things, you really need to have a think about, is this translatable into a condition that meets the tests? And it's not me criticising it, it's just kind of thing that sometimes when they do come from people like that, they haven't got that mindset to think about that. But as worded, there's lots of things in there that you could take issue with. I'm not going to take issue with it because nobody's raised an issue, but I think. 32, this is the word works. I don't know what works are, or operations, or extraction.
My concern was it refers to principles, and it's a principle and an outline scheme rather than details.
And in any event, it's wrong, because we've got the wrong plan.
Yeah, I've noted that.
All right. That requires a rethink. That's not precise. 33 is a standard landscaping condition that comes from the County Land Council's landscaping scheme. Any trees that nobody die removed for the period if I can read it, I can repeat it without looking at it.
But is this all trees planting forever on here, or is this the restoration, the bund? It's just, what does this actually relate to in terms of the stages?
I take it that it relates to the restoration scheme and its implementable phases, but maybe we need to just say that.
We are proposing some advanced planting around the footpath, so I would imagine it would apply to any trees or shrubs planted. Yeah.
Within any phase. All right, that just needs to be tighter. 34. Prior to commencement of development, hereby approved a revised planting scheme. Oh, that frightened the life out of me. What's a revised planting scheme?
I mean, we have put planting details on the landscape operational phase plan and the restoration plan. I presume it's just to confirm the exact details of the plants.
Right, so what we're trying to say here is we're not departing from the approved restoration plan, but the approved restoration plan requires elements of detail. That's not a revised planting plan. That's the details of the planting to achieve the objectives of the restoration plan. That's not what that says.
Agreed, sir. We'll amend that.
Right. 35. Arboricultural practical commencement development hereby approved. Revised arboricultural method statement reporting. What does that mean?
It's a pretty standard one, isn't it? But for my reading, at least point E should be part of the SESS in terms of the tree protection measures.
I'll tell you, that whole condition requires a rethink. And the reason why is because the first part, you've got to read it about 5 times before you even get a gist of what we're trying to achieve. B in particular, some load bearing provision. What the heck is that? I don't know what that is. The quarry manager will carry out weekly inspections of the tree protection fencing, make a record of the inspections. It doesn't have to fix them. Just have to say, yeah, it's gone. That's gone. The whole condition is it's one that's you've had it. Somebody said put this on, but there's lots of things that's not right there. It doesn't didn't meet the tests of a condition.
Take your point, sir.
So I'm not going to say any more. Oh, right, 36. What's the difference between a local authority tree and a tree?
We need a plan.
Is that I don't know. I don't know what the difference is between a local authority tree that's specified in the condition and a tree, and that's not me being flippant. Until compensation is agreed and paid in full.
I think this relates to the 3 trees at the point of the access that are due to be removed and compensation, because I think they could be on highway land.
So those trees need defined in a plan. So those are trees T1, T2, T3 shown on plan. No works to those trees. And this is requiring payment. Is this something that should really be in the section 106?
Yes, this is one of the conflicts.
This is not a planning condition, is it? Requiring payment. I don't know how much payment it should be.
We don't know that yet either. It's to be defined through the CAVAT calculations.
I'm nervous of that one as a planning condition.
Okay.
It seems to me that there is compensatory payment to be made of a value that I don't know, in the mechanisms that I don't know, relating to trees or I don't know. And for me, that sounds to be not a planning condition.
We agree, sir. With Mr. Hammond, we'll move it into the 106.
Right, let's got just over 5-10 minutes left. Noise. I'm going to read this out because there will be some issues. Sorry, the gentleman at the back. Sorry, I haven't got my glasses on, so I do apologise. Yes, I can. Yep. Yep.
underneath the Nicholson estates is a World War II munitions dump.
Right.
Wait, if you take a big hole onto the peninsula, you are then going to change the water table that the World War II munitions people estimated how slowly that dump would go into the river. And
Okay.
if you go in the middle, that's going to accelerate the rest of that dump.
I'm going to stop you there. I'm sorry, I'm going to stop you there. I'm going to stop you there. I can't take comments about that. We're on the planning conditions. I hear what you say. I'm dealing with the planning conditions. There's a planning condition deals with ammunitions, but I'm not going to take comments. I said that quite clearly earlier. I'm sorry, I'm not going to permit that. We need to carry on. 37, the noise management plan. Tell me about your concerns about that, Ms. Else.
Sorry, I got off piece there. Given the likely impacts and the feedback that have been given by local residents so far, specifically traffic, the routing, extraction, those sorts of things, we would have expected something a little bit more detailed than this noise management plan outline. This seems to be the minimum that would be necessary, and that we'd expected to have, as we've indicated before, a much better synergy between the operator, the parish council, and a better ability to make feedback to advise the operator where things are going wrong, where noise mitigation, where HGV routing, all of these sorts of things are not satisfying the conditions or the condition requirements. So it's really going a little bit further than the complaints procedure and making more detail in terms of the mitigation.
Right, okay, there's a whole, I think 36, 37, 38, 39 deals with noise. And I agree with you because they kind of come in separate chunks, but don't seem to kind of line up to me.
And the reasons for some of the conditions seem to demonstrate that the mitigation that's been justified through the EIA assessment and through the evidence hasn't actually been
Right.
assessed, and that new figures are needed.
These need to line up with the noise information in the environmental statement.
So, for example, 37 refers to this is a pre-commencement condition, and as such details need to be considered prior to commencement and thus go to the heart of the planning permission. If it goes to the heart of the planning permission, then surely this should have all been clearly identified already, when actually this is all to be submitted.
All right. There is the noise scheme, there is a noise information in the environmental statement. What I'm probably saying is the condition needs to be a little bit more robust, because it needs to understand what you're starting with, what's the impact, how do you manage that impact, what you do if that impact's causing a concern. I can't go beyond what's in the noise assessment because I've got no other information to suggest that's wrong. But the condition is to just ensure that those parameters are being met and there's an adequate and enforceable regime that's monitoring noise that can take steps to redress issues with noise should there be an exceedance of the values that's specified in the noise assessment.
That's right. And then in 38, where it refers to 8 weeks in one calendar year, this isn't really appropriate in terms of the extent of time, the impact on potentially the schools and other areas of risk. We're really asking for a shorter period of time, and that it better refer to the school calendar. So 1 calendar year doesn't necessarily mean that it actually takes into account the years of operation of the schools where that's the highest risk. Equally, the points that have been raised is that some of the noise measurements and some of the figures that I've put forward haven't taken into account the noise at the site entrance and the activity there.
I'm not going to go beyond the environmental statement. I can't. But I do take your point about the relationship between the activities of soil stripping and school times, because you will know when you're going to strip the soils. You'll know contractually when you're going to strip the soils. You will know from an operational perspective when you're going to strip the soils. So there's kind of...
I think we have said, probably not in writing, but that we would be happy to try and avoid, do the works nearest to the school. For example, the construction of the bund, which is going to be the noisiest part of that operation during school holidays. And I'm happy for us to think about how that can be reflected in that condition.
And I think that's a point you're making.
Yeah, and content aside, it's just badly worded.
Yep.
For a period of up to 8 weeks, that's a sort of what we're trying to achieve.
Yep.
Well, we're not. We're trying to minimise it.
There's no reason why you couldn't give notification of those stripping arrangements
No.
anyway, because you're going to be able to do some of that as part
Yeah.
of some of the other conditions that's
Yeah.
dealing with soil movement.
I think the reference to the up to 8 weeks in one calendar year is just the government guidance about exceedance of that noise limit. That's straight from
that's
the
come from
guidance.
the PPG.
Yeah, yeah.
Doesn't work as it's been written.
That's not being the wit of man to achieve your objectives and achieve the requirements of the school. So I think about that one. Air quality and dust. First part of that 40. I don't know how the hell the planning authority enforces that.
I mean, we could put signs up. It could be a condition requiring signs to be up for that speed limit.
You need to have a think about that. I'm not going to suggest ways, but you need to think about that. I know why it is to minimise dust emissions from transport vehicles, but from a planning condition perspective, in terms of enforceability, it's difficult as worded.
Take your point, sir.
Dust management plan, we're nearly there. Dust management plan. This is a point of contention of the local community, I think, and particularly in terms of particulate monitoring. I think my only thing I would say is that I think you need to satisfy yourselves whether or not that is robust and achieve some of the concern that's been expressed. You need to achieve them anyway, even if they weren't expressed. You've probably got some concerns about that condition. I've got some concerns about that condition. I think it just needs a rethink in terms of what we're monitoring, what's the exceedance, what do we do if we get the exceedance, is the monitoring adequate, where should it be, how long should it be in place, who's
How it's
doing it,
enforced. Yeah.
and it's bish bash bosh.
And ideally, from our point of view, we wouldn't want the existing dust management plan that is referenced included. We'd want agreement of a new plan that takes into account all of the things that have been identified in evidence and also in your comments then.
I'm going to leave that to these. I hear what you're saying. I'm not going to say anything more than I think that just needs a little bit of rework. I don't think the council's being robust enough in that condition, if I'm being quite honest.
No, we take the point, sir, and we'll be talking with the county.
And get rid of those words works.
I take your point on that, sir. I have looked at it, the whole schedule in regard to that, so I'll make sure the amendments are reflecting that.
Okay, 3 to go. Aftercare. Site should be restored to grazing land with recreation used in accordance with the approved plans shown on. Alright, we've got the right plan there. And the outline landscaping restoration, aftercare revision B. I assume that's the right aftercare scheme. Updated version. Why do you need a new aftercare scheme?
I think it was just outline submitted, and I presume the county are expecting a more detailed scheme.
That's correct.
Would it fundamentally change the condition that's in condition 42? Is it more detail?
No, I think it's just about the kind of the maintenance of the restoration. It's not about changing the plan at all.
So 44 is the details of the aftercare scheme, but it doesn't change the principles of the aftercare scheme in 42.
Yeah.
That's not what it says, is it? Because what this is saying is, you've got an aftercare scheme now, you throw that away, and in 2 years' time you have a completely new aftercare scheme. That's as the condition says. That's not what you mean, is it?
No, it's not so.
All 44 is providing the detail of the aftercare scheme, but the principal aftercare scheme framework never changes. Right. 43. I have some issues with 43. What was it? This is providing, in the event that work ceases, this is giving 2 years, and if nothing happens, you have a restoration scheme. Not an issue with that. I think the issue that I had is that the second sentence refers to the agreed timetable, but the first part of the condition doesn't even ask for a timetable. So again, it's the part when you were expecting that revised restoration scheme, what are you expecting to be submitted? It should be a revised plan that covers the whole of the site that's been affected by the development. I said operations then. And it requires a timetable for the implementation of relevant works, probably in a phase, because there's got to be soil moved about, and it's that then that gives you the enforceability of this is when it's got to be done by. But the condition as worded doesn't require a timetable.
Take your point, Sarah. We'll take that one away.
All right. Do you have anything else?
My concerns about that were equally about the lack of timetable, but in terms of putting forward possibly a revised restoration scheme, does that change the conclusions of the environmental statement? Does that require new ecological surveys?
Can't go there. That's life, isn't it? Sometimes things don't work out as we plan. We have to have a revised scheme. So I'm not going to go back to the environmental statement because you're opening up the right kind of worms there that applies to every single development in the whole world. This is really about if they stop work, it gives the authority powers to enforce restoration as a site stands there. And there's a scheme then to be submitted to do that.
So it's the time periods that
yeah, it's the time period. You ain't going to go back to the environmental statement. You can't do that. Otherwise, you're going to be sitting in inquiries for years arguing that point. The last one is plans. Unless and I've asked you to check 3 times now, unless somebody says those plans are wrong, that's the agreed plans list.
I found one error.
Oh no!
But this, the ITB 13040 SK006 revision I.
Just take, where are we down?
It is 1, 2, 3, 4th line up, or 5th line up, going down. It says SK006 revision I, and I think it's the next one. I think from my notes.
Revision J?
Yeah. That just needs confirming that I've found the right plan.
We can check that again, yep.
That's it. All right. Again, I'll put a note out on this next week, but you need a fair bit of time to go through these because some of that's going to be affected by what you say in highways evidence. Some of that needs to reflect on what's been said on hydrological evidence. Not so much ecology, but it's just ensuring the ecological objectives of restoration are going to be adequately delivered. And I'm sorry that kind of pulled apart some of those things, but we had to do it. But you've got time to do it. Hopefully it's given us a thought to, think about the tests of conditions and not what environmental health give us and the Southern Water and the Environment Agency. It's given us a chance to tighten up the Section 106 agreement and ensure we've got clear. And somebody before we sit needs to just do that sense check that do these things line up. Because if not, I'm going to get myself telling me this is not right, sir. And I'm not being critical there, I'm just saying, you'll tell me. So ensure the line up. All right, we've probably said enough on those at that particular point. You've got plenty of work to do.
Thank you for the time and thank you for your comments, sir.
Thank you for your contributions as well. And I apologise, but we had to go through the exercise.
No, so that's perfectly understood.
Right, you can go if you wish. I can go straight into speakers now, or is anybody desperate for a comfort break? No, let's go. Carry on. All right. That's concluded the. Mr. Strawn, you need to come back. I'm going to suggest probably that revised list of conditions, as indeed with the section 106, is provided the week before we resume. So you've got plenty of time to do it.
I was rearranging. Could you repeat that?
I think I'll ask for those revised conditions and the revised 106 to be submitted to me, to PINS, the week before we recommence. Plenty of time.
That is very generous, sir. Thank you.
It's fine, because I think you need to have that discussion. If you sent me it early, I'm not going to have time to do much with it. But what I think we're going to have to do is to have a little bit of a session, only a mop-up. I'm not going to go through this exercise again, because then I should have what I have. But I'll just have a mop-up just to ensure that the section 106 is okay.
Understood. Yes, sir.
All right. All right. This part of the last part of today in terms of this room is we have 7 speakers who would like to speak to the inquiry. I'm going to read out the order that people have indicated to speak, and then when people do speak, as I've done before, I'll invite them to the witness table. I'll ask them, are they in opposition or support of the proposal? I'll also ask them if they would be prepared to take questions from Mr. Strawn. I mentioned earlier you don't have to answer the questions from Mr. Strawn, but if you do, it may affect the weight that I place on the evidence that you give at the witness table. The order that I'm going to call people is, first of all, Councillor Keith House, Sarah Sutcliffe, Brian Trindle, Timothy Thorburn, Thubron, and you're going to have to explain to me how you pronounce that. Thubron is what I've got. Andy Daniels, Bill Blaine, and Phil Riley, whose statement I think is going to be read by Janine Austin. So could I call Councillor House to the witness table? Thank you, Councillor House. Thank you for that. Thank you very much indeed. Amy, I'll call that speaking note of Councillor House as inquiry document 15. Councillor House, can you introduce yourself and can you just confirm to me whether you're in support or objection? I probably know the answer.
Yeah, thank you very much.
Should Mr. Strawn have questions of you, be prepared to answer those?
Yes, thank you very much, sir. My name is Councillor Keith House. I'm speaking in opposition and very happy to answer any questions from Mr. Strawn. So, my name is Councillor Keith House. I've served as Eastleigh Borough Council leader since 1994 with planning policy in my portfolio. I've also served as the County Councillor for the appeal side since 2001 and as a member of the County Council's Regulatory Committee, which is its planning committee. I moved the reasons for refusal based on the officer's report and information available at the time. I'm an honorary member of the Royal Town Planning Institute and advised the coalition government of 2010-15 at the Chancellor and Secretary of State's request on enhancing housing delivery by local authorities. I'm not here as the Rule 6 party and have not consulted with the Rule 6 party on this evidence. I'm familiar with the appeal side, having visited many times over more than 20 years. I'm a former member of Hamble Parish Council and have followed this process over 19 years now since the first consultation on the site by Hampshire Council. I regret that the county's regulatory committee was not engaged by council staff in the decision of county staff to overturn the committee's decision. It has been suggested that County Council, as policymaker and decision maker, had an interest to mark its own homework in getting the application agreed, with a reluctance to address community concerns at the Regulatory Committee. So I very much welcome, sir, the opportunity of this appeal to consider the many issues raised by this application. I've removed many paragraphs of this evidence to avoid repetition of details raised on Tuesday afternoon session: noise, dust, economic impact, and most significantly, public health. These were not NIMBY submissions, usually heard at appeals. Far from it. Let me start with local policy. It's agreed the starting point for local policy is the Eastleigh Borough Local Plan, the EBRP, adopted in 2022, and the Hampshire Minerals and Waste Local Plan HWMP adopted in 2013, following 8 years of development. The EBRP is clear that development at Hamble Peninsula should be restrained. It says at para 3.7 little l, there should be no, and I quote, there should be no significant additional development in the Hamble Peninsula because of transport constraints, mineral safeguarding, and the vulnerability of the open and undeveloped countryside gaps between settlements in this area and Southampton, the outer borders of which are clearly visible from many parts of the peninsula. And this statement reflects the policy decision of the Highway Authority, Hampshire Council, that adopted policy on Hamble Lane on the 12th of March 2019 in a report to its Cabinet Member for Environment and Transport that, in para 3.2, in referring to its own scheme of improvements, said, and I quote, there is a need for an improvement to help address existing traffic problems and to help manage future demand associated with background growth. It is considered that additional development along the corridor would compound the existing problems and would negate the benefits of the scheme, with very little opportunity to make further improvements to the corridor in the future. Therefore, until at least the preferred scheme for the northern section has been implemented, it is considered inappropriate from a traffic perspective for further development to be allocated or, and that is my emphasis, sir, permitted along Hamble Lane. I will refer to the Hamble Lane Improvement Strategy, the HLIS, shortly, but for now the keynote is that although the policy allocation for Hamble Airfield was stated in the adopted HMWP of 2013, the CEMEX application was submitted more than 2 years after the adoption of the county's restraint policy on the 29th of December 2021. The specific policy on Hamble Airfield in the EBLP, included only due to the status of the adopted HWMP, is HA1 as follows, and it is worth quoting. If permission is granted for the extraction of sand and gravel at Hamble Airfield and the extraction takes place, the site shall be restored in accordance with the Hampshire Minerals and Waste Plan, and it shall be retained as an area of accessible countryside and open space with grazing, public access and outdoor recreation facilities laid out to the satisfaction of the Borough Council. There's explanatory text on HA1 giving useful background and future policy direction in the context of this policy. There are several paragraphs there, so I'm happy to read them out, but I'm happy to take them as read if you like.
Read out what the bits that you think are crucial to making the point. I think, Councillor Officer, I don't want you to be denied the opportunity.
No, I'll try and paraphrase rather than read the full text. The policy notes that there is a supply of allotments in Hamble that are sufficient, but likely that they'll be under pressure in the future. The history of the site is outlined and notes that notes again that the site should be restored to countryside and the public rights of way adjoining the site should be retained and where necessary improved, and also points out the restored site should only be used as an area for public recreation and countryside uses as well as for general grazing. And the Borough Council then notes in its policy that it would be prepared to consider to use outside sports on some of the land as well as for public general amenity space. So, moving on, the issue of displacement of leisure activity, such as walking to more sensitive locations, is a real one and was raised on Tuesday. The Royal Victoria Country Park is simply not a viable alternative. Clearly, the Borough Council is now reviewing its local plan, and as such, it's at the very earliest stages of that process. A call for sites was instigated in summer 2023, with an issues and options consultation that ended in January 2025. The airfield site remains under promotion, but the Borough Council has not identified this as a likely site for development. The site remains in the countryside and partially in the settlement gap, simply safeguarded for minerals extraction due to its current position in the HMWP, subject to that plan's own ongoing review. Any statement on future housing development on this site must therefore be purely speculative and will be a major policy change for both the local planning policy, Eastleigh, and Highway Authority, Hampshire. Let's just turn to a couple of recent appeals for clarity on this position. 2 significant appeals held since the introduction of the County Council's restraint policy are worth considering to see the Planning Inspectorate's weight given to traffic issues in this area and the County Council's stance on applications since the introduction of its policy. Firstly, an application at the GE Aviation site in Kings Avenue, Hamble, was dismissed on the 15th of January 2021 for 148 dwellings to the north of the factory site on the west side of Hamble Lane, south of the primary school. The appeal related to an application submitted before the County Council had adopted its restraint policy for the Hamble Peninsula, whereas the appeal was heard after its adoption. The appeal was dismissed by the inspector on a number of grounds, including the, quote, unacceptable effect of traffic movements and highway safety, and it's worth considering 6 paragraphs of the inspector's decision in full. I think these are worth reading, sir. Paragraph 48, the financial contribution towards the HLIS will be focused on works to the Hound Road and Portsmouth Road junctions initially, with the scope of any unspent monies to go towards other improvements. The TA models the impact of proposed mitigation measures at the Hound Road junction and conclude that sufficient capacity would be achieved. Based on the robustness of the baseline data and the modelling for this junction, I have no reason to disagree. In contrast, there is no modelling in the TA of mitigation measures for the Portsmouth Road junction or any others. The Hamble Lane Corridor Study, which informs the HLIS, does not make any provision for improvement works at the Hound Road junction. There are no costs for the work other than the applicant's suggestion of the inquiry that they could be around £1.3 million. Hampshire County Council currently holds £2.33 million towards the HLIS, with a further £1.27 million to be secured, including the applicant's £750,000. This is significantly less than the total estimated cost of the HLIS, which dates from 2017. Even allowing for contingency and overly optimistic estimates, it is not clear whether there is sufficient funding to carry out the works within the HLIS. Hampshire County Council continue to wait for a decision from the Department of Transport on its pinch point fund to relieve local congestion. County officers have also indicated that more assessment will be required even if the bid was successful, along with a further 2 years to start construction. The report continues, it is conceivable that individual elements of the HLIS would come forward in a piecemeal fashion, including the Hound Road and Portsmouth Road works. However, there is a lack of mitigation modelling for most of the junctions and uncertainty over the funding and construction timetables. Therefore, I conclude that the HLIS-related mitigation measures are unlikely to be sufficient or come forward within a reasonable timeframe. Although these measures are based on the residential trip generation only, the inability to demonstrate that they are appropriate and can be delivered casts doubt on the ability to mitigate the traffic impact of the development. It is also important to note that I found flaws in the changes to Kings Avenue and Coronation Parade in the previous main issue. The approach to baseline data and much of the modelling work is adequate, but doubts remain on the effects on the Windover roundabout junction due to the absence of specific assessment. Overall, I find that the mitigation measures are uncertain, and so the development will be likely to have an unacceptable effect on traffic movements within the local road network. Hampshire County Council's lack of objection to development is clear, despite some confusion created by the timing of a March 2019 County Council report to the Executive Member for Environment and Transport, which states that until improvements to the northern section of Hamble Lane have been implemented, it is considered inappropriate from a traffic perspective for further development to be allocated or permitted along Hamble Lane. The main parties have also disputed the wording and meaning of the Council's third reason for refusal. However, from the evidence before me, I conclude that development would have an unacceptable effect on traffic movements and highway safety. As a consequence, the development would not accord with policies 100T, 101T, 102T and ELP policy DM13. Amongst other things, these policies require development to minimise its impact on the existing transport network, avoid interference with the safety, function and standard of service or the road network, and provide contributions towards traffic improvements. The development would also not meet NPPF paragraph 108C, which seeks to cost-effectively mitigate to an acceptable degree any significant impacts of schemes on the transport network in terms of capacity and congestion. NPPF paragraph 109 is also applicable, which seeks to only prevent development on highway grounds if there would be an unacceptable effect on highway safety or the residential cumulative impacts on the road network would be severe. A second appeal, sir, land at Satchel Lane, was dismissed on the 20th of December 2022 for a less substantial scheme of 61 dwellings to the north-east of the airfield and east of Hamble School. The inspector dismissed the appeal for a variety of reasons, not including highways, but noted that the County Council supported the Borough Council position on traffic issues. Let's move on to securing improvements for Hamble Lane. All of the above indicates the difficulties in accommodating more traffic on the peninsula. The underlying issue remains the very nature of the peninsula, with one way in and one way out. As a consequence, Hampshire County Council has been seeking to secure developer contributions to mitigate traffic over many years. It is worth noting and examining the results of that strategy. Following a request to Hampshire County Council, details of developer contributions for transport currently held by the county were provided for the Hamble Peninsula on the 25th of February. Of these, schemes for permissions as old as 2012 secure contributions of just over £2 million for improvements along the Hamble Lane corridor. To this date, over 13 years, less than £32,000 has actually been spent. Now, this three Section 106 agreements for land at Hamble Lane, Berry Farm and Cranberry Gardens in the northern part of Hamble Lane, which secured those developer contributions for highway improvements. As referenced earlier, Hampshire County Council adopted a comprehensive strategy for Hamble Lane on the 12th of March 2019, following consultations from 2016, with a set of recommendations agreed at the Executive Member for Transport and Environment's Decision Day. Recommendations agreed delegated full implementation to County Council staff. 12 key elements of infrastructure improvement were identified, with in paragraph 8.1 of the report 6 key priorities. 1. Online widening of the northern section of Hamble Lane to provide a second lane southbound between the Tesco access and Portsmouth Road, and a new shared use footway cycleway on the eastern side of the road. 2. Signalisation of the Portsmouth Road junction, including the partial reopening of Lowford Hill. 3. Signalisation and widening of the Jerd Way junction. 4A, so there's really 7, revised access arrangements for the Tesco store, new improved existing car park egress and access via the A27. 4B, revised access arrangements for the Tesco store, new signal-controlled left-in, left-out junction on Hamble Lane with new U-turn slip from Hamble Lane northbound north of the Tesco access. 5. Signalisation of the A27 Portsmouth Road junction. And 6. Signalisation of the Satchel Lane and Ham Road junctions with Hamble Lane. And I've given a reference to that document on the County Council's website. As of today's date, not one of these proposals has been subject to any public engagement, design or planning for implementation. On the evidence, it's hard to reach a conclusion that Hampshire County Council is capable of implementing schemes to improve safety along Hamble Lane, and hence the justification of a restraint policy for new development that will create additional traffic. The proposed mitigation that has been accepted by staff of the County Council without reference to the Minerals and Waste Planning Authority, which is the regulatory committee on behalf of the County Council, barely scratches the surface of the impact of the application, even if accepted. With a very limited rail service to and from Hamble Station, the diversion towards sustainable travel will at least be marginal. That is before considering that much of the critical impact of the appeal proposal, which is additional heavy traffic at the more congested northern part of Hamble Lane, is not mitigated at all. Now, I wasn't able to be present to hear yesterday's discussion on traffic, sir, but the unique nature locally of Hamble Lane, with its reliance on Windover Roundabout and 6 other significant junctions or roundabouts before reaching the proposed appeal site junction, all close to capacity at morning and evening peak, makes the case for restraint. When a bucket is already full of water, even a few additional drops leads to overflow. The final sentence of the County Council's own report, in paragraph 3.2 referenced above, makes the policy position clear, and I repeat, therefore, until at least the preferred scheme for the northern section has been implemented, it is considered inappropriate from a traffic perspective for further development to be allocated or permitted along Hamble Lane. In conclusion, sir, Hampshire County Council had every right to promote the airfield site for mineral extraction, despite the objections of the local planning authority, 3 local parish councils, and an overwhelming response from the local community. In doing so, the test was to see if a planning application could be capable of overcoming the legitimate and reasonable concerns demonstrated. Since the adoption of the Minerals Plan, the County Council, as Highway Authority, has sought to restrain development on the Hamble Peninsula. The county's review of its plan is still subject to results of that examination. None of the additional post-determination information between the applicant and county staff has been considered by the County Council's elected members who determined the application. The evidence there is clear. This proposal cannot be sustained without demonstrable harm, with no realistic prospect of significant mitigation of traffic or other objections, and as such, sir, the appeal should be dismissed.
Thank you for your contribution, Councillor Wells. Just one thing before I introduce Mrs. Strawn. You didn't miss the discussions on highway matters yesterday because we didn't get there.
No, I had to write this assuming they'd been heard, but
no, I appreciate
so I'm quite happy to take that correction.
No, it's not a correction.
Yesterday.
I'm just saying you have that
Yeah, no,
opportunity
sure.
when we resume back in June, because
Yeah.
the first day back in June
Yeah.
is not the first day of June, the first day we resume in June, I think it's the 24th, is a discussion on highways issues.
I will be here for that, sir.
No problem. Mr. Strawn.
So thank you. I was going to make exactly that point, and I was also going to make the point that the issues you're raising we're going to cover to a large extent in the traffic session. So you'll forgive me if I don't put questions to you, which I'm going to put to others.
No, thank you, sir. I hope I've given you a prelude to some of those issues from a locally elected representative's perspective. I would only add to that perhaps to perhaps just give a pointer to that discussion, whether it helps either side or not, I don't know, is that traffic data of the Hamble Peninsula has always been a thorny issue. Studying data on any one particular date or series of dates is prone to produce unexpected results. Given this issue, the road is at capacity on its major junctions. It just takes a small incident or a small amount of additional traffic at particular times to tip it over the edge. And that's something I think which does need to be thought through very carefully with this application.
Councillor House, thank you for your contribution to this inquiry. Can I invite Sarah Sutcliffe, please, to the witness table? Thank you, Ms. Sutcliffe. If you could perhaps explain to me whether you support or objection to the application. When you introduce yourself, if you could explain who you are, who you represent. And can I ask you, before you do start, if Mr. Strawn has any questions for you, we'll be prepared to answer those questions. Yes, the button on the right-hand side. It should, and the microphone should light up. That's it.
Great. Yes. Oh, good afternoon. Thank you for the opportunity to address the inquiry this morning. I am here in objection, and I am willing to take any questions that Mr. Strawn would like to put to me. My name is Sarah Sutcliffe, and I am the Chief Executive Officer of the Royal Yachting Association, which is based in Ensign Way, Hamble. We have submitted written objections throughout, and we take these as read and do not intend to repeat them today. The Royal Yachting Association is the national governing body for dinghy, motor, sail cruising, all forms of sail racing, ribs and sports boats, windsurfing and personal watercraft, and is the leading representative body for inland waterways cruising in the UK. We are also the body that runs the British sailing team, the most successful Olympic sailing nation in history. We were founded in 1875. We are celebrating our 150th anniversary this year. We are a membership body with over 100,000 members and 1,500 affiliated organisations, including clubs and training centres in Hamble itself. To establish an active quarry in the middle of a small community of Hamble with only one road in and out is totally unfathomable. It does not make sense on any level and will destroy the fabric of the village. We object to the proposed quarry being built in Hamble for a number of reasons. 1. Hamble is historically and presently an important sailing location based on the Solent. It has both a national and international reputation as such, and thousands of visitors annually. Sailing and boating is central to the community and provides hundreds, if not thousands, of employment opportunities. The RYA chose to move its national headquarters to Hamble over 20 years ago because of this very connection. We are an island nation with a rich maritime history and a vibrant maritime industry, all of which can be found in Hamble and is at the heart of the community. We fully support the submissions and objections raised by the sailing and boating communities and industry and do not repeat them here today. 2. The RYA is a significant employer with over 190 employees, of which at least 140 are based in our headquarters in Hamble. 22 are residents of Hamble and the other 120 commute in, either from the surrounding areas or from further afield. 3. As an employer of local Hamble residents and families, we fully support the submissions and objections from the local community regarding air quality, road safety and proximity to schools, which will undoubtedly be damaging to children's health and education. 4. As an employer of more than 120 commuters, including myself, we have significant concerns about the disregard being shown to the impact on the roads, both in terms of congestion and safety. Anyone who needs to use Hamble Lane knows only too well how heavy the traffic is on any given day. And when there are roadworks or an incident, it is total gridlock, cutting the village off. In fact, I would question why a business such as Cemex, that itself relies on the roads being operational to move its truckloads, would think it is a good idea, being reliant on a one-way in, one-way out road, and that already experiences regular congestion. The lack of reliable and accessible public transport exacerbates this issue. Without doubt, as an employer, the relative inaccessibility of Hamble already impacts our ability to recruit and retain staff, and it is often cited as a reason for leaving a job with us. This will only get worse. 5. As a business, we pride ourselves on having strong sustainability credentials. We monitor and report on our commuting habits so that we can calculate our carbon footprint. I cannot, in all consciousness, encourage my staff to walk, cycle or use public transport when the air quality will be affected and HGVs are thundering up and down the narrow road. This impacts our ability to deliver on our corporate sustainability strategy. 6. As a business, we also regularly host events such as board and committee meetings, stakeholder events, regional staff visits and training weekends, all of which means we are a regular user of other Hamble businesses, be it accommodation, restaurants and cafes. Should our ability to operate effectively as a business be drastically impacted, we will have to consider our long-term future. 7. As a business, we own 2 buildings on the Ensign Way Business Park. The value of these assets, one of which is leased to tenants, is affected if Hamble is not a location businesses want to operate from. That in turn affects our viability as a business, all of which makes for a vicious circle in terms of our investment in the local economy of Hamble. We cannot and do not accept that the revisions submitted by Cemex have gone anywhere near far enough to address the valid reasons that planning was initially refused, and ask the inspector to look closely and interrogate the reasons behind the change of position of Hampshire County Council in particular. Finally, this is not a case of NIMBYism because the quarry is simply undesirable or an eyesore. Rather, Hamble is a totally unsuitable location for a quarry. It creates an unacceptable and irreversible threat to the very sustainability of the village, its businesses, its families, and the fabric of the community. The Royal Yachting Association respectfully urges you to refuse the appeal. Thank you.
Thank you for your contribution. No questions, Mr. Storm? Thank you for your contributions.
Thank you.
I might inadvertently refer to Ms Sutcliffe as a Police and Crime Commissioner. You're not. You're not. But that does bring me to a point of my inadvertent omission. Donna Jones was going to be here today to speak on behalf of the... I've got you. The Police and Crime Commissioner, and I missed her off my list. In any event, she's not here today, but her representative, I think it's Mike Ottaway, is here. So I'm going to, because she was going to speak anyway, I'm going to add it to the list. So we might slightly go over past 1 o'clock, but we'll carry on. We've only got 5 more people to deal with. Can I invite Mr. Ottaway, who is representing the Police and Crime Commissioner, but is not the Police and Crime Commissioner, to the witness table, please. I've probably introduced you there, Mr. Ottaway, but perhaps if you can just explain your role with the Police and Crime Commission, and also confirm to me whether or not you'd be prepared to answer questions, should Mr. Strong have any questions.
Certainly. My name is Mike Ottaway. I am the Head of Estate and Facilities Management for the Office of Police and Crime Commissioner. I also represent the interests of the Constabulary. I am here to read a statement on behalf of Donna Jones, who objects to the application. It's quite short, so it might not impact your 1 o'clock too badly. The Police and Crime Commissioner for Hampshire and the Isle of Wight, Donna Jones, has raised significant concerns regarding the impact of the proposed Hamble Airfield Quarry scheme, which would be located opposite the main entrance to Hampshire and Isle of Wight's Constabulary's Southern Support and HQ and Training Centre. The proposed scheme will inevitably lead to a significant increase in heavy vehicle movements between the proposed quarry site and the strategic road network. The main highways affected will be the same highways which serve the police training centre and headquarters buildings. The Commissioner has serious concerns regarding the impact of additional traffic will have on the users of our site, which includes police officers and staff. Officers also work in the 24/7 police control room. The police control room is one of the most critical frontline operational assets the Constabulary has within its fixed infrastructure. It is impossible to relocate and was subject to over £1 million of investment and upgrades in 2023 to ensure that it was fit for purpose and able to serve the public 24/7. The control room, however, does require staff to ensure its operational capability. Therefore, the proposed increase in heavy traffic along Hamble Lane and the indirect effects on other minor local roads will impact the ability of staff to access and exit the site efficiently and safely. The Commissioner is concerned that the increase in heavy traffic along the road network will increase the likelihood of incidents along the highway network, increasing the likelihood of blockages, incidents and delays which may further impact the Constabulary in accessing the headquarters site. Since the police control room was built in 2000, there has been significant housing development along the route of Hamble Lane between the Windover roundabout and Hound Road roundabout, with very limited improvements to the local road network, primarily due to the lack of opportunity to expand or increase the highway due to existing residential properties which line the B3397. The lack of expansion to accommodate the residential development has increased traffic volumes significantly during peak rush hour times. The application by CEMEX will only increase the traffic volumes not only at rush hour but throughout the day. The quality of the highway surface is already poor and requires significant disruption to Hamble and the local areas due to its one road in, one road out arrangement to resolve. These matters will only be impacted further by the proposed increases in heavy traffic. If the requirement for aggregate is of such importance, why are measures not being taken to capitalise along the local rail network, which shares a boundary with the airfield site, for the transportation of materials away from the site to mitigate a proposed 150 heavy vehicle movements each day? As a Police and Crime Commissioner, it is my duty to ensure an effective policing service is provided to the residents of Hamble and Hampshire and the Isle of Wight. It is my opinion that the proposed scheme will have a negative impact upon the Constabulary's ability to ensure its critical functions are resourced correctly to respond to the public, and as such, the application should be denied. And yes, I'm happy to take any questions. So.
Thank you, Mr. Ottaway. Mrs. Strawn, just bearing in mind it's not the Police Crime Commissioner, it's comment on their behalf, so with that in mind.
I've got that very much in mind, and the fact that we're going to deal with transportation next time we meet, so I haven't got any questions. Thank you very much.
Did I correctly get your name right? Mike Ottaway? You did. In which case, Mr. Ottaway, thank you very much indeed for your contribution, and on behalf of the Police and Crime Commissioner, and please reassure her that your comments have been heard, or her comments have been heard. Thank you very much indeed.
Thank you.
Can I invite Brian Trimdrell? You know what I'm going to say, Mr. Trimdrell, so when you sit down, just say, yes, you either will or won't answer questions, and then introduce yourself and your position.
Thank you, sir. Good afternoon. My name is Brian Timbrell. I am the owner of 104 Hamble Lane. My house is located in a run of 12 similar properties, 86 to 108 Hamble Lane, to the east of the road. They are the nearest to the proposed entrance, and 108 is adjacent some 70 metres away. The houses are also the closest residential sensitive receptors, nearest to the plant as well, and are at a distance of some 50 metres from the areas designated for extraction, and all would be confined behind the highest section of the bund, which is projected to be 5 metres. And if you look upwards, the ceiling is about that height. So imagine that at your garden end. The letter objecting to the planning permission was endorsed by 11 of our neighbours. As regards demographics, there are about 30 people in residence, the youngest 5 years of age, the eldest approaching 90. The quarry has been described as a temporary undertaking,
However, if developed as planned, our quality of life would be adversely affected by additional traffic congestion, dust, noise and vibration throughout the life of the project, before even any protections are put in, from the first day when preparatory works commence until such time as the entire site has been restored to nature, circa maybe 2040. For some, that would be for the rest of their lives, when they're not the most active people and vulnerable, while for the young children, it would last throughout their formative years into their early 20s. The entrance presents risks as it's proposed. We already have difficulties crossing the road to the bus stop or to the station. We see near misses quite often, people mounting pavements, people overtaking, and this happens during school time, on the cycle path, the pavement, the road itself. If permission were granted for an entrance to be opened up, we believe a thorough risk assessment would then be called for. It might well identify the need for traffic calming, controlled access of egress and access. The second strand that I want to touch on is that bunds do not provide a panacea, and many studies have shown that. Turning to the specifics, and I will lodge this paper, I'm trying to hurry, if that is okay. Building a bund around the parameter to screen views, it was explained by representatives of CMEX that to do it at 3 to 5 metres would, if you were standing in a first floor upstairs window, you would not see into the quarry. There are many instances where there are stockpiles and machinery envisaged which would exceed those heights. And indeed, at 5 metres, it wouldn't protect second floor accommodation. Our neighbours have accommodation on the second floor and they've looked down into the bowels of the operation. Air quality too is a moot point, whether it would or would not protect us adequately. We know already there is a difference between the dust in our front windows because we're near the road. In the back is a sanctuary at the moment. We worry about the consequences if at the back of our properties, within 50 metres, which is half a number of other measurements that have been quoted, we have dust and particulates which we can't, as medical people have explained, see or control easily. In short, we have the feeling that we could be living on an experimental front line. Imagine being at a distance of less than 75 metres when a refreshing sea breeze sets in on a hot summer afternoon. Is that an attractive one, especially as it is usually the time of day when people are able to enjoy their gardens, open their back windows to air their houses and let their children rush outside to play after school? Is that to be taken away? Is the ability to talk in the back garden, listen to bird song and conversation to be drowned out? We don't know. It may be that it's possible to mitigate everything, but the jury's out on that. Some people say earthworks are good at absorbing sound, even if they don't mitigate vibration. But sound travels back and forth. It reverberates. It can echo already off our back walls when we hear foghorns or motorcycles using Satchel Lane, perhaps. Even if CEMEX use so-called white noise rather than high-pitched bleeps as their vehicles move around the site, it's been, through studies, suggested that it's detrimental to health and well-being over sustained periods of time. So, that is all to look forward to. And again, on hot nights, when it's difficult to sleep, how many of you would want to be trapped behind closed windows without the option of opening up to a refreshing breeze? It is easy to say this is all NIMBYism, but there are also particular things that I've also want to just touch on before I lodge the paper. When our house was being purchased, a ground stability hazard was spotted. It manifests itself under the airfield just outside of our property, but a bund is now proposed to be built on top of it. This isn't to talk about other issues of hydrography that have been mentioned, but we all know of where bunds or embankments have collapsed around the country. That bund is projected to be there as a temporary measure, but it's going to be for many years. How stable is it going to be? Our back gardens are already waterlogged during the months. That's natural. But what additional runoff may come off this bund which comes down from the height of this ceiling to our gardens? And then again, there's light pollution. The site plans include pylons, clusters of LED lights at heights, which clearly exceed the heights of the proposed bunds. Studies have shown the intensity and wavelengths of light emitted from LEDs can be detrimental to the long-term health and well-being of both animals and humans. At present, we enjoy almost dark skies. So, what I've tried to do is give a snapshot of a group of people who actually feel quite threatened and vulnerable, with proposals that it is difficult to be sure of the detail on. This morning's session was very helpful with that, but at the end of the day, it revealed there are management issues to consider. So I conclude by echoing what people largely said on Tuesday. Locating a quarry on the site of the former airfield would be just too close to all the sensitive receptors nearby in Hamble, including us as residents. Our long-term health and well-being is important. The short message is that it is not possible to guarantee that the risks to health, safety and welfare can be mitigated. Therefore, on behalf of myself and my close neighbours, I would urge you to turn down the appeal. Thank you very much for affording me time to contribute, and I'd be happy to take any questions.
Thank you, Mr. Trindle, for your comments. Mr. Strachan, sorry, Mrs. Strawn, I do apologise because I was reading your nameplate and it just went.
Well, thank you very much. No questions, sir. Thank you.
Thank you very much. Thank you very much for your contribution to this inquiry. Thank you. Could I invite Timothy, and please help me with your pronunciation. Thubron. Yeah. Timothy Thubron. And I do apologise for saying it wrong earlier, Mr. Thubron. Again, if you could just tell me who you are, who you represent, whether you object, and whether you're prepared to answer any questions.
So, as I've said, I'm Tim Thubron from Satchel Lane, Hamble. I object and prepared to answer any questions. Thank you. I've been living and working in Hamble for over 20 years and sailing from Hamble for over 30. During this time, I've worked extensively in the marine industry as both a professional sailor and sailing manager, organising and running racing at many of the local sailing and yacht clubs, therefore giving me an extensive experience and knowledge of the local winds in Hamble and adjacent Solent waters. Consequently, I actively, usually daily, often more frequently, monitor and study both the wind forecasts and live weather data in and around the local area. This experience, combined with a degree in marine navigation and RWA Yachtmaster and Ocean Master qualifications, mean that I should be considered a suitable authority to talk about the local wind patterns. According to the Met Office, the area around the Isle of Wight is listed as one of the top windiest locations in the UK. It is a well-known fact, also stated on the Met Office website, that coasts are windier than low-lying inland areas due to the sea surface producing less friction than the land. It is therefore disappointing to see wind data from Southampton Airport, which is approximately 10 kilometres away from the Hamble airfield site and a low-lying inland area. Data from Southampton Airport is not representative of the wind on the Hamble Peninsula. Hamble Airfield sits on a raised plateau that dips to the east and south. By contrast, and I quote, "The airport is geographically situated in a natural gentle depression or bowl due to the surrounding topography." This is taken from the Noise Action Plan 2018 to 2023 Southampton International Airport Limited. They are not similar or comparable sites, yet CEMEX have relied on wind measurements from the airport for its air quality, dust management strategy and noise strategies. CEMEX could have put their own meteorological survey station on the airfield at any time since they have had an interest in it, I believe at least 13 years, but have never done so. They rely instead on data from Southampton Airport, specifically chosen for its more sheltered site, which effectively channels wind to be from the southwest. The dust management plan, for example, states the prevailing wind data show that for approximately 76% of the time, wind speeds are likely to be below 5 meters per second when dust is unlikely to become suspended in the air. So I ask, what is wrong with this statement? Well, firstly, as mentioned, the location of the data being used is naturally going to have a lower speed. To put this into context, wind speed at Southampton Airport, a sheltered site, on Monday, 31st of March, never peaked at over 5 meters per second. But closer to the site in the Solent, just south of the site and closer than the airport, winds were twice as strong. Secondly, this data is over a 24-hour period, and wind, particularly in Hamble, is stronger during the day. The National Weather Service states, at night, surface cooling reduces the eddy motion of the air, surface winds will back and decrease. My own experiences are that the winds in the local area have been changing over recent years. Some would even cite global warming, with many more extreme conditions now being experienced. I would also note that the CEMEX data is not current, having used data only up to 2019. It is interesting to note that the wind in Hamble for the last month has been predominantly coming from the east. Today the wind is east-northeast. It has been predominantly from the east and north for some time, and is forecast to be from the east and north for a further 2 weeks at least. My own sailing experience, particularly in the summer months, is that Hamble and the surrounding areas, Southampton Water and the Solent, are frequently subject to localised sea breeze thermal winds that regularly blow from different directions. Indeed, a study by the University of Plymouth found that the component sea breeze was the most frequent type of sea breeze in the Solent. Component sea breezes usually blow from the southeast sector. I'm concerned that CEMEX have tried to lull everyone into a false sense of security, suggesting the wind direction will mean noise and dust carried by the wind will not unduly impact the village, but let's take a more detailed look at the wind direction. Recent data recorded at a local weather station, actually in Hamble, located just 370 metres south of the southern edge of the airfield, clearly shows that southwesterly winds are not dominant. Indeed, data recorded every 5 minutes between March 25th, 2024 and March 24th, 2025 reveals a more accurate picture of my own wide-ranging experience, with just 15% of the data showing wind in the south-southwest, southwest and west-southwest sectors. In percentage terms, the most frequent wind directions recorded were from the south, 10% of the time, blowing straight over the airfield towards the Hamble School and the medical centre. West-northwest, also 10%, blowing across the airfield to the village centre itself. And east-northeast, again 10%, bringing breeze across the airfield towards businesses in Ensign Way, like Cooper Vision, for example, and much of the residential area in Hamble. According to these numbers, one or other of the schools would have been downwind, so therefore impacted for more than half the year. Breaking this down further shows that the core Hamble village residents and businesses would have been directly affected approximately 42% of the time. Winds from the west-northwest, northwest, north-northwest, north-northeast, northeast, east-northeast over the last 12 months. The lack of mature foliage on the eastern perimeter of the airfield means that Hamble River and its shoreline are particularly exposed. These wind directions and likely increased wind speed would undoubtedly heavily contribute to higher levels of dust and noise pollution for any proposed gravel extraction on the airfield site, impacting the whole community. Thank you for listening. I welcome any questions.
Thank you for your contribution, Mr. Thurwell. Mr. Straw.
I don't have any questions. Thank you very much.
Thank you for your contribution today. Thank you. Can you invite Andy Daniels, please? Mr. Daniels, exactly the same questions. I'm not going to repeat them. You can tell me the answers to those as you sit down, if that's all right.
Andrew Daniels, representing the perspective of Hamble cyclists and objecting.
And happy to take any questions. This is in two parts. I've been asked to read a statement on behalf of Danny King, now Danny Rowe. In the interest of brevity, I'll read a heavily edited version, but the full version is available. Danny's name was given to the shared pathway on Hamble Lane after winning gold in the velodrome at the London 2012 Olympics. And we'll also get a gold letterbox, which I have to say has been maintained better than the cycle path. I'll then describe my own experience and concerns shared by fellow cyclists in Hamble. So Danny's words. My representative stands before you today to express my strong objection to the proposed quarry on the disused airfield near our home in Hamble. As a proud former resident of Hamble, where I was born and raised, I attended both primary and secondary schools in this community. The safety and well-being of my hometown and its residents are of utmost importance to me. I am deeply concerned that the proposed quarry threatens the integrity of the Danny King cycleway. Furthermore, CEMEX's own survey acknowledges that there is a short section over the railway bridge where cyclists are required to rejoin the carriageway. This presents a major risk to cyclists, and yet I have found no reference to this concern in the responses provided. This oversight indicates a worrying level of complacency and a lack of care. While I do not object to the proposed changes to the western side of Hamble Lane leading to the station, I question why these changes are prioritised over all other necessary safety measures. Who is making these decisions? Where is their focus on ensuring the safety of school children and all shared path users? In summary, the lack of serious measures to protect shared pathway users is alarming. The proposal is poorly conceived and fraught with risks. The County Council's failure to adequately safeguard school children and other path users suggests a lack of understanding regarding cycling and walking along Hamble Lane, and particularly at the proposed junctions. I object to this proposal with such conviction that I would consider removing my name from the path if the quarry is approved. It would only be a matter of time before someone is injured or worse, and I refuse to have my name associated with such a tragedy. Thank you for considering my objections. Sincerely, Danny Rowe, née King. And the background to my own perspective, 7 years of bicycle commuting in London before moving to Hamble in 2003, 15 years of road and mountain bike racing. Since 2003, I've ridden between Hamble and Windover at least 2,500 times on my way to Winchester, Southampton, Fareham, Hedge End, Botley, Chandlersford and beyond. I ride on the shared path always, but not because it is safe or convenient. It is neither of those things because of all the junctions and driveways that cross it, the poor surface in many places, the narrow stretches, and also because it is shared with pedestrians. So the only thing to do is to ride defensively and slowly. I use it because I don't want to hold up the traffic by riding on the road. Cars cannot overtake without crossing into the other lane into oncoming traffic. So a cyclist has a dramatic effect on traffic flow. But I know that there are plenty of cyclists who do always and legally ride on the road and never on the path because it is slow without any safety benefits. And in any case, the path doesn't go all the way to Windover, so we all have to join the road at Portsmouth Road anyway, which is well documented as the most congested part of the route. Other things that make it a less than encouraging experience are the guaranteed soaking on a wet day from the southbound traffic, driving in the standing water on the eastern side of the road between Satchel Lane and Mallard Road, which also happens to be the stretch with no verge and where the speed limit is 40 miles per hour. Even with all my experience, it is quite intimidating when an HGV is coming down the road at 40 miles per hour with practically no separation or protection. So turning to the proposed mitigation, let me quote from various documents on the planning portal submitted by Hampshire County Council, Eastleigh Borough Council and CEMEX. Let's say mitigation is required to ensure that appropriate opportunities to promote sustainable transport modes can be or have been taken up given the type of development and its location, and any significant impacts from the development on the transport network in terms of capacity and congestion or on highway safety can be cost effectively mitigated to an acceptable degree, though I noted that it doesn't actually say who it needs to be acceptable to. Other points, cyclists must be separated from volume traffic, both at junctions and on the stretches of road between them. Barriers, such as chicane barriers and dismount signs, should be avoided.
routes should be designed only by those who have experienced the road on a cycle. And overarching principles: prioritise walking and cycling for healthier people, healthier transport and a healthier planet. The mitigation compliance statement from Hampshire County Council, I'm afraid to say, leaves me literally open mouthed with what it is claiming to do for Hamble's sustainable transport. It uses the word sustainable travel scheme to describe, which is, well, it's a little bit confusing. We're not sure if it's 200 or 700 metres of tarmac and a crossing. Georgie Baker demonstrated on Tuesday how confusing the proposals are. Anyway, while it might be partial mitigation of the entrance to the quarry, it is not the material and net improvement needed to promote cycling and walking as is claimed and required. The statement also references the secondary school and claims that paths will be widened, which is not true, as the mitigation on the eastern side stops before the quarry entrance at the crossing point, and the narrowest paths are north of there, and where 90%, if not more, of the school children will be, together with the cyclists riding north of the station. I've also seen in a very recent rebuttal proof of evidence document that excuses are already being offered up to dilute what is being proposed, because in some areas it would seem that there might be some difficulties. In summary, not on any one of those 2,500 journeys did I ever think to myself that what I needed was a path up the western side of the road between the primary school and the police college. So like everybody else on the peninsula, cyclists are wondering how we arrived at this point when the improvements to Junction 8 and Hamble Lane, deemed necessary in 2016 and 2017, have not been made. And now a confusing, insufficient mitigation scheme has been accepted by Hampshire County Council. I'm afraid to say it feels like a token gesture and is just not acceptable to Hamble's residents, and lives are at stake here, unfortunately. That is all. Thank you.
Any questions? Mr. Strawn, any questions?
Thank you very much, sir.
In which case, thank you for your contribution to the inquiry. Thank you. Can you invite Bill Blaine? Exactly the same questions, Mr. Blaine. If you can just answer them as part of your opening, that will save us all a little bit of time. Thank you.
Absolutely. I'll be very pleased to take any questions afterwards. My name's Bill Blaine. I live in Hamble. I commute up to London, where I'm a professional financier, investor and economist. I'm a regular commentator on the BBC and other media. I'm also Professor of Economics at the prestigious Edinburgh Business School, part of Heriot-Watt University, where I lecture the postgrads on investment management. Today I'm going to talk about the real world of economics, rather than the very interesting experience I've had learning about planning today. But we live in a real world, and I'm going to talk about the economics of the quarry and why mistaken assumptions about waste illustrate multiple grounds that you as the inspector should reject this appeal. I've spent a lifetime dealing with company boards, and it's taught me to dig deep and never accept what I read in a pitch book, a company statement, or a nothing to worry about proposal. So the first question I'm going to ask is about any business decision is why? And the second is, what are the likely consequences? Because these are the things that affect the real world, which is always changing. So let's ask why Cemex is so determined to dig a quarry in the heart of our prosperous village. We know that there's little value in the gravel Cemex intend to dig out, and we know that there's between 7 and 12 years supply and multiple mothballed gravel quarries. We know that there are alternatives, including Cemex themselves, dredging exactly the same gravel geologically from the Solent, providing the useful by-benefit of keeping the channel deep enough for shipping. We know that demand for quarried gravel is falling because construction firms want sustainable alternatives to demonstrate that they are cutting their CO2 emissions. And we know that most construction waste is now recycled into sustainable aggregates and cements, a factor that was not anticipated when the requirements for strategic mineral plans and waste plans for aggregates were set back in 2013. When the facts change, you should change your mind. And the only imperative to quarry gravel that is apparent in anything that CEMEX propose is that now outdated statutory plan for minerals and waste, which includes the gravel and sharp sand. There is nothing else in terms of need for gravel that has been demonstrated. Now, as a financier trading in the bond markets and equities, I give CEMEX great credit for spotting this opportunity to make a fast buck. What they are doing is arbitraging now obsolete rules, and they are doing so with the connivance of the owner Persimmon, who's been repeatedly denied permission to build on this site. They're playing a long game, betting that once the airfield has been brownfielded, they'll finally be able to build in it. Now, we've highlighted throughout this inquiry the concerns of residents about health, safety, and the local economy. But I won't bother going into that in detail. I will simply explain to you the way that quarries work. The value of a quarry is not in the gravel that they are going to dig out of it. The value is in what they are going to put into it as infill. And that is the key to the real motivations, the profit imperative driving this quarry. You see, the thing is that waste has a price. Waste disposal firms earn fees from disposing of rubbish with no economic value. Now, CEMEX has reassured us in all their details that they're going to infill this and it will be managed by a company called Inert Recycling, which is a very friendly name that I'm sure gives HCC every confidence that non-toxic, impermeable, inert waste is going to be buried on the site. I would, however, note that it appears to me that this company, Inert Recycling, seems to share the same address as CEMEX. That would immediately set alarm bells ringing for me if I was to consider refinancing this company. Now, they've stated in the documents we looked at this morning that it will be impermeable infill to be used from construction, demolition, and excavation waste. These are the only things that will be permitted on site. But the thing is, that kind of inert construction waste is now increasingly scarce. Why? Because construction waste has a very high economic value because it can be recycled into processed aggregates and artificial cements, which are better from a carbon neutrality. Everybody wants to use these materials. Nobody wants to use things like quarried gravel if they can avoid it. Now that creates double trouble for CEMEX. It means there's a falling price for the gravel that they intend to extract and a rising price that they will have to pay for any infill that they put into the site. Now, the temptation then arises for CEMEX to find something else to put in. And this is why I raised the question that when the facts change, you have to change your mind. Because the reality is that the waste that will be available for infill will be more dangerous, more polluting, and dirtier and toxic. And guess what? The more toxic they are, the more CEMEX stands to win. It's entirely possible, I would say even likely, that at some point in the very near future, CEMEX will seek to maximise returns from the quarry by burying high-grade, high-gate fee earning waste on site, and that will include things like landfill, toxic, and other household and industrial wastes. None of these are impermeable, none of them are inert. They will leach toxic chemicals into the water table and into the river, and none of that has been properly analysed in the documents we have seen. Whatever drainage is put in place will not change the leaching effect. None of that is supposition, that is fact. The hydrology reports are all based on the highly questionable assumption that inert, impermeable materials will be available. They may not because of the rules of economics making it too pricey to do so. Now, CEMEX has given us the kind of bland statements about negligible risk that have so characterised this inquiry, but they're making all the wrong assumptions about the kind of waste that will be available. These statements should not satisfy you as the inspector at all. This is a much bigger risk than anyone has analysed or is prepared to accept on the CEMEX side. And it raises a very interesting question. Who is going to actually police and stop CEMEX filling this entirely unnecessary quarry with toxic waste? And there is precedent here, because the dismal state of the UK's waterways is a result of ineffective regulation by Ofwat of the privatised water industry. Precedent. Failure to stop CEMEX poisoning the water table and river will result in greater damage in the future, and we've raised this now. It needs to be addressed now. And that leads me on to a statement that was made at the beginning of this on sustainable development. I wish to record my objection to Mr. Strawn's describing the quarry as sustainable development in his opening remarks. As a financier, if I was to describe Hamble Quarry as sustainable development, I would be in breach of the Financial Conduct Authority's rules on greenwashing. That is when you falsely describe an investment as meeting sustainability and environmental, social and governance objectives. That offence would be punishable by an unlimited fine and me being banned from the financial industry permanently. Poisoning rivers while putting 2,000 local marine jobs and the 200 million local economy at substantial risk and pollution is not sustainable development. Now, at this stage, I'd like to pose a very rhetorical question, which obviously I would not expect you to answer, Mr. Burlington, to simply ask, which is the more important legal rule? The fact that we now have obsolete strategic materials and waste plans telling us that we need to have provision for a quarry, or the fact that the UK government, and I also believe Hampshire County Council, are obligated to meet and support the United Nations 17 Sustainable Development Goals. These are environmental, social and governance objectives. Of specific relevance to this quarry application are number 3, good health and well-being, number 6, clean water and sanitation, number 9, sustainable infrastructure, number 14, protection of the sea environment, life below water, number 15, protection of the land environment, life on land, and finally, number 16, social justice. These are all legal things that the UK government has signed up to deliver in terms of good governance, social justice and sustainability. It leads me on to the most telling thing that I've heard in this whole inquiry. A young lady, one of the pupils at the school, who said they value sand and gravel as more important than our lives. Well, the lives of 15,000 of us on that peninsula, 2,000 jobs and the local economy are already at risk because economics works now. Already we are suffering the aggravation. We are seeing businesses make plans now on future jobs and future expansion based on the potential damage that this quarry will create. It's not going to happen in 3 years' time or over the next 20 years. It's already damaging the value of our economy, the prospects of our children, and the value of our homes. It has already put us into damage. Now, I ask you all here, but you especially, Inspector, is it right that these citizens who have been so let down by Hampshire County Council are going to see their lives so dramatically impacted by the corporate greed of CEMEX, a Mexican company with a history of very poor local relationships? Go ahead and Google it, it's very simple. And ultimately, Persimmon the Landover. It's time to reject this appeal because of all the things that this whole inquiry has shown in terms of the deficiencies and the misallocation of data that we've heard about so many times, and now add into that the way that they're going to try and fiddle the waste as well. They will not be able to use impermeable waste. They will end up filling that site with landfill, and we all know it. Thank you very much for your attention.
Any questions, Mrs. Strawn?
No questions. Can I just make it clear that we don't recognise the majority, if any, of that?
That's a question.
No, that's a statement to me, Miss.
You've had your moment of making a various numbers of assertions. Clearly, on behalf of the appellant, I reject all those various allegations. It's not going to be a productive use of time now for me to cross-examine someone, but I don't want it to be thought that we accept all of those allegations, and you, sir, will be well aware of the regulatory context that applies to what is put back into the quarry. But I don't want it to...
If it's helpful, Mr. Strawn, I know my responsibility in terms of relative data, the relative information, the relevance to planning action, environmental data. You probably know what I'm saying. So what I'm really saying is I know the bits I pick out of that and I know the bits I don't pick out of that, if that helps.
No, I'm grateful for that. So it's just more that people listening may think, because I'm not asking questions to respond to that, that any of those allegations are accepted. They are not.
Thank you. Thank you very much for your contribution to this inquiry. Can I invite Mr. Riley? This is the last speaker. And I think Ms. Austin is going to speak on behalf of Mr. Riley, and that's it. I know we've run over a little bit, but we've dealt with all the interested party speakers now that's on my list. Ms. Riley, I'm not going to ask you if you're going to answer questions because you're speaking on someone's behalf, so that will be unfair. So if you can please present your comments on behalf of Mr. Riley.
Thank you. I'm representing Phil Riley, a Hamble resident who strongly objects to the CEMEX proposal. He was here on Tuesday but couldn't be here today. Good afternoon and thank you for the opportunity to speak. I would like to ask a straightforward question and attempt an answer. The question is simple. How much mitigation is too much mitigation? The question arises from a concern that the number of planning conditions contained in the statements of common ground between the appellant and the Minerals Planning Authority and Hampshire Highways are both numerous and complex. As far as I can make out from the statements of common ground, there are at least 24 areas that need conditions of S106 agreement. They include multiple conditions on noise limits, daytime temperature limits, working hours, bunding, noise, management plans, machinery maintenance, environmental and dust control measures, lighting design and operation, plant site layout, risk management for subsidence and unexploded ordnance, types of infill, tree planning, fencing and revised restoration schemes, soil and contamination management plans, permissive access, ecological mitigation, and last, but certainly not least, a 30-year post-extraction management plan. Those with far more experience of this process than myself, Phil Riley, clearly I'm not Phil, tell me that they have rarely encountered a development with so many layers of complexity and so many planning conditions, both defined and still yet to be determined. This isn't just a quarry application, it's a legal, environmental and logistical maze. And let's be clear, many of these planning conditions are still undefined. The restoration plan is vague. The community access meadow, often cited by the appellant as a public benefit, has no defined size, no S106 backing, and no guarantee it will remain post-restoration. It was never consulted on publicly. If it is not in the legal agreement, how can we be sure it won't disappear with the next planning application? Then there's the permissive path, not a right of way, but a temporary offer that can be revoked at any time. Worse, this one is supposed to be tied to Ideal Homes, Persimmon, who are the landowners, yet there's no binding 30-year obligation for access. And let's not forget the Planning Authority's proposal for vehicle restrictions. No HGVs leaving the site during the school drop-off and pick-up, but they can still enter. There's no risk assessment supporting this. Why does the planning authority consider this is acceptable? I'm curious to understand how this compares to CEMEX's other quarries in Hampshire, such as Hamble Quarry in Ringwood or Brams Hill. Even a cursory examination of those sites on Google Maps show their impact on the local community is minimal compared to the Hamble proposal. In the fullness of time, of course, 50 or 60 homes might be built immediately adjacent to those sites, with a large secondary school and playing fields added for good measure. Until then, there is no comparison. This is about transparency, accountability, and enforceability. Planning conditions mean nothing if they were vague, negotiable, or unenforceable, and in this case, too many still are. And with the proposed devolution of Hampshire County Council and the district councils on the horizon, who will actually be responsible for ensuring that any of these conditions are enforceable, monitored, and upheld? And who will do so transparently and fairly? The community is asking, above all, for oversight that puts the safety and well-being of the public, especially their children, above convenience or profit. I started by asking how much mitigation is too much mitigation. I actually suggest the answer is self-evident. And I would conclude with a final question. On what planet is Hamble Airfield the right place for a quarry? Thank you.
Before you leave, I want to thank you for organising the speakers and reducing the numbers down. So thank you for the contribution, but more importantly, thank you for the way you've gone about trying to resolve some of our time pressures. I appreciate that.
Well, we all appreciate how difficult it is, Mr. Normington, and I will be sending a pack with all of the speakers' notes.
I've been advised.
And separately, I'd like to send a pack of the notes that weren't for the people that weren't able to speak, just to make them feel.
Did say that we would make provision for that. I'm sure. Yeah, fine.
Thank you.
Absolutely fine. Thank you. All right, we're about 25 minutes behind schedule. It's better than we have been, if I'm being honest. Thank you for everybody's contribution this morning from the community and elected representatives. Thank you for your patience and contributions to the roundtable session on the conditions. Yeah, we had a bit of a go around things. It's not unusual on mineral cases. So it might sound that might be a bit alarmist that I've gone through things like that, but it's not unusual because there's lots and lots of conditions and lots of things, and we're all human, and sometimes we don't get things right at the first attempt, but by collective effort we do get them right, hopefully at the second and third attempt. So please take that as it was. It wasn't intended to be any criticism by any of us. It was collectively working together to ensure that the conditions and the 106 is fit for purpose and nothing more than that. That's it as far as today's proceedings go. It's 27 minutes past 1. I'm suggesting probably, I'll try to be off for 1:30. We're not going to be off for 1:30, are we? To be fair to everyone, you probably need a little bit of time to have some lunch and get changed. So we're going to have to go back to the 2 o'clock bus, I think, unfortunately. And I do apologise for that. But we are where we are, but everybody's had their say. Just a reminder that there are things that will be outstanding. I will send a note out. It'll probably be Tuesday because I'm on leave on Monday. I'm not getting out of bed when I get home. I'm stopping there all week. I'm kidding. But I'm on leave on Monday, so it won't be Monday. It'll be Tuesday when I send something to John. But I'll just set down some parameters of timescales of what's expected. I'll revise the programme just to confirm that contingency for Thursday morning, and I'll alter my arrangements for that as well. Amy, over a period of the next few weeks, will be sending me no doubt things to John about the information that's been provided. I'll probably just send you, when you return from your holidays, a inquiry document number list so you can match the numbers to the documents that you've sent. So I'll try and do that. Unless there's any other aspects of housekeeping that going to crop up, there will be things crop up between now and June, but those will be subject to the normal communication channels between PINs and respective interested parties. I don't think there's anything else of housekeeping that I need to say Mr. Trimble, do you have a? Yep.
Is there a time envelope which is typical after that when a decision is likely to be known? Because clearly
Yep.
those theories are living day to day the same lives.
There is that I can't tell you. I will try and touch upon that towards the end of June when we sit in June. I'm not going to commit myself to anything now. There are checks and balances, I'm sure you would appreciate, that we have to go through. And there are lots of competing time things that I need to consider as well. So I cannot give you a definitive date. I can give you a ballpark, and it is an incredibly ballpark towards the end of June, but not now. Because there are lots of things that I need to do and lots of checks and balances that I need to go through as well for obvious reasons. So it ain't going to be within 2 weeks after June, I can assure you that. But it will be sometime probably before the autumn. That's all right. Anything before we formally close? Mr. Strawn, anything else?
No, thank you very much, sir.
And I do apologise because, Mr. Fulbrook, anything from yourself?
No, thank you, sir.
I apologise because I look at, I've got my glasses on, and that's part of my problem because I can't. You remind me of somebody, and I'm frightened to name you by that name, so I look for your nameplate, then realise I can't see it.
Well, I'm wearing my glasses today, so I'm sort of disguising as my.
I can see it perfectly
disguise,
now,
yeah.
so I hesitate because I've done it before, call someone by the wrong name, and you remind me so much of. I'm not going to say who it is, and I've been tempted on 3 or 4 occasions, like I've called Amy Emma, to call you by that, and that's why I stop. And then I think I need to refresh my mind. I can't read it without my glasses.
I can only hope that it's a positive.
It is a positive.
Not negative.
It is a positive. I'm not going to tell you no, but it's a positive. I can assure you that. You're all right. You're safe. Nothing from yourself. Mr. Lewis, anything from yourself?
Nothing from the council. Thank you, sir. Nothing.
In which case, can I thank everyone for their patience and contribution over the last few days? I'll be saying this again in June. Just a reminder, when we resume in June, it's 9:30. It's back in this room for the first 2 days. If we do run over, which we probably will, it'll be in the ante-room for the final closing session. But I will put a programme out that hopefully confirms all that you should be able to access it on the council's website as you have been doing the information. So I'm going to close there. We will meet in the lay-by. Is it the lay-by? At 1 o'clock. Oh God, wish it were 2 o'clock. And then we'll commence a site visit from there, and I'll be led entirely by the parties on that site visit. So you lead me where you want me to go. I'm not going to lead you, if you know what I mean. Thank you very much indeed for your contributions. We now adjourn until the 24th of June. Thank you, sir. Thank you.